One. And as a reminder, this meeting is being recorded. Angela, could you please take the roll call to start?
It's Sarah Vanola.
Present.
Ken Bacon.
Here.
Elizabeth Bradley. Raquel Brown. Cassidy Shivers.
Here.
Justin Fields.
Here.
Brandon Krieger.
Here.
Joel Mark.
Here.
Eleanor Mercado. William Munoz.
Eleanor
Mercado's
here.
Daniel O'Reilly.
Here.
Nikita Poindexter. And Hunter Starr.
Here.
Thank you.
Okay, and next on the agenda is the call for public comment. Angela, do we have any individuals who wanted to give public comment?
Yes, if anybody would like to give public comment at this moment, please use the raise hand function. And if you are participating by phone, you can raise your hand by pressing *9. So if you would like to give a public comment, please raise your hand or press *9. It does look like we have some people. Each public commenter will be given 2 minutes to make their remarks, and we will have a 30-second verbal warning. So first up, we have Reverend Frank. Reverend Frank, go ahead.
Good morning. How is everybody doing today? Just wanted to let you know that, I don't know if Leah told you, they've had to open up a state bar complaint against your chairman, Rand, because meetings back in 2020 can't seem to find the recordings. And you would think that when Leah sent the state bar's response for my Freedom of Information Act, that she could have included reference to even one email that was sent scheduling this meeting, except nobody can. So it really appears now that those 9 meetings may have been entered into the system at a later date and not recorded. So I'm just concerned that they're going to not do a very good investigation. So Leah, if you're listening in, I would suggest you check your email as to who I just sent some stuff out to, because I don't think the clients, the City of Fontana, Ontario, the Port of Hueneme, and the Southern California Association of Governments, I think these people that hired Ruben for their, what do they call it, their city attorney and their general counsel, I don't think they're going to be too happy when they find out there's a state bar complaint open against him. And he probably hasn't even told them yet. So you guys have a great weekend. I know I'm going to. Thank you.
Thank you, Reverend. Next up, we have Todd Hill. Todd, you may start when you're ready.
Good morning, all. Thank you very much for the opportunity to speak this morning. I do have an item that really is, I think, directly related to an area that you guys are tasked with developing rule sets for and developing recommendations for. And in fact, I believe there's actually a duty you have to, when there's conduct that is far afield of conduct that is in conformity with statute, you have a duty to report it. Not simply as, for those of you who may be attorneys or licensees under Rule 8.3, but as those of you who have been appointed or accepted some kind of appointment or staff position in an area where there's an imperative to protect the public. As most of you are aware, I had filed a case number 2:23-CV-01298-JLS. That case number again is 2:23-CV-01298-JLS. And it is related to my period as a law student, now more than 4 years, where I am not, after completing the entire curriculum at my former school, I've not been able to transfer. I've not been provided viable transcript. the state bar subsumed the duties, obligations, and responsibilities of the school, which it regulates as the vertical monopoly regulator in the sphere for legal services for student education. It subsumed those duties, but it has not performed any teach out, it has not performed anything as a viable remedy to assist me when the school was reported for misconduct. I'm almost done. In fact, it was assisted by the bar for some period of time. And so here I've submitted a lengthy written comment. That comment never seems to appear in any of the meeting minutes that you guys are about to approve. And so at this stage, I'm not sure what this committee's goals actually are. Although for those licensees, the reasonable and foreseeable consequences of conduct are imputed to be intended. Thank you for the time.
Thank you, Tom. Are there any more public comments? Please use the raise hand function. Okay, that's it for public comment, Sarah.
Okay, thank you. And I think next on the agenda is the approval of our last meeting minutes from July 28th, 2023. Does anyone have any corrections or modifications to those minutes? Not seeing any. May I have a motion to approve the minutes from our last meeting? I'm seeing Joel, your hand's raised, but you're on mute.
I said, so moved.
Okay, great. Thanks, Joel. Do I have a second?
Second.
I will now take the vote to approve the last meeting's minutes. Ken Bacon,
Proof.
Raquel Brown,
Yes.
Elizabeth Bradley, Cassidy Chivers,
Abstain.
Brandon Krieger,
Approve.
Joel Mark,
Yes.
Eleanor Mercado, William Munoz, Dan O'Reilly,
Yes.
Vikita Poindexter,
Yes.
Chris Dodd,
We're getting some feedback from the LA conference room. I'm having trouble hearing.
Raquel, it looks like you're on mute. Are you trying to speak?
I have my hand up to be acknowledged. Yes. So I wasn't trying yet till I was acknowledged. It's related. Yeah. So I don't know. It's related to the minutes. I think member Poindexter, were you at the last meeting? I think you weren't. So she said yes, but I think she has to abstain, correct?
She's not required to.
Oh,
she
okay.
may.
Okay. All right. So that was all.
Okay, so the last two votes that I didn't take or hear, unfortunately, is Hunter Starr
I'll abstain.
and Sarah Vanola.
Yes.
Okay. 7 in favor and 2 abstain. So motion carries.
Can I raise a point of order very quickly? It's hard to distinguish who's in the San Francisco conference room. Could we have those identified? Is that
Yeah, I think that makes sense. I do.
hard to read? Your little postage stamps. there.
I can see Dan, Justin, Angela, and Erica.
Okay. Got it.
So
Thank
those are the 4, unless I'm missing anyone that's not in. Okay. And
Okay,
I don't
I'm
see anyone in
satisfied.
the LA conference room. Is that right? I thought there was, we have that on video, but I don't see anyone. Is anyone in the LA conference room?
No, you're correct, Sarah. So we, I'll get into that in the staff report, but there were some changes that came through for Bagley Keene Wednesday evening, I believe it was. And so that's why LA is showing and SF is here, and we can talk about that a bit more in a moment.
Okay, all right, that makes sense. And I think next, let me just look at my notes. Next on the agenda is the chair report. So I'll just briefly give a report on that. The one thing I wanted to check in on is I know Angela had circulated an opportunity to provide a CLE on implicit bias for the San Mateo County Bar Association Funky Credit Day. So I wanted to see if, first, Angela, did you get any interest from members for that panel or for that speaking opportunity?
Vikita had expressed interest, and then Raquel had inquired as well.
Okay. So yeah, I'm not sure if exactly if the San Mateo County Bar Association is looking for a panel where it could be a 2 or 3 or wanted an individual speaker, but we could follow up on that. And if anyone else is interested, I just wanted to let everyone know in case you missed the email to let Angela know. And then the other thing that I just wanted to say is I was debating whether to say this at the end, but today is my, I believe my last meeting as the chair. And I know there are 2 other members that are departing the committee today that I'm sad to have leave. One is Justin, our current advisor. Today's his last meeting. And I just wanted to make sure I had time, so I'll just do it at the beginning, I think, just to say goodbye. I feel bad that I couldn't be there in person. I was planning to go to San Francisco today, but I've just been kind of swamped. I've got a big briefing deadline due on Monday. But I'm sure I'll get an opportunity to see you again in San Francisco sometime. But I've just really appreciated Justin's role as advisor this year and his, past participation on the committee. He's always provided such helpful feedback on the opinions and most importantly, I think helping to make them more concise and clear and focusing on kind of the big picture and really simplifying some issues that can be complex. I think that showed a little bit in connection with our recent COPRAC Ethics Symposium where we did the recent developments, and Justin took the lead on trying to discuss what we're going to get to later today, which I always found to be kind of a difficult opinion to digest, but he really presented it in an effective manner, which is the lawyer as an expert witness opinion. And I know he's had a big role in a lot of the other ethics opinions as well. And so I just wanted to make sure that I thanked you, Justin, for all of your hard work and very helpful feedback. And I will miss you not participating in our future meetings. And I also wanted to make sure I thanked Ken, because I think, Ken, this is your last meeting as well as a COPRAC member. And, your insight on a lot of the ethics issues and particularly the issues involving fee arbitration, given your experience as a former fee arbitrator and that committee, it's been invaluable. And I know you didn't initially really want to do the AI panel for our ethics symposium. That wasn't necessarily your first choice, but you eagerly accepted it. And I thought you did an amazing job in putting together that panel and serving as a moderator. The feedback I got, a lot of people really appreciated how diverse that panel was. And I think that's very important as we put together these ethics symposiums. And I thought the speakers you got were amazing. And this will be a very important issue going forward, as we all know. And the other thing that I will miss a little bit, to be honest, is just seeing your granddaughter show up every so often.
I have lots of pictures.
on these Zoom meetings because she's so adorable. But yes, but I just wanted to make sure that thank you, Ken, for all of your contribution committee. So I think that's it. And I've been just, I know we've done a lot through my years on this committee, not just the ethics opinions, but with the recently, providing feedback on some of the rule changes that I think are important, like the civility amendments. And I'm hoping when we get to the next report by Erica, she'll provide a little bit of update on that. And then also the rule 8.3, reporting attorney misconduct. So anyways, I just wanted to thank the departing members. And I think I'm going to turn it over to Erica for a brief staff report.
Thank you, Sarah. Yes, I'll be very brief. So as I kind of just discussed, there are some changes that were made to Bagley-Keene through urgency legislation that went into effect, I believe it was Wednesday evening, and that's through SB 143. So they are very temporary through December 31st of this year, but they essentially will allow us to go back to what we were doing prior to June 30th. So for those of you who will be attending the October meeting or December meeting remotely, those can be fully remote meetings, although I believe we're choosing to have October in person in Los Angeles. But for December, basically what that means is everyone will be able to be remote. We will not have to notice locations, and the public will be able to attend the meeting remotely. So that may be a little bit more convenient for many of you. This meeting had already been posted when that change went into effect, and so that's why we continue to have the LA building as an open option for members of the public that may wish to attend, as well as us here in SF. So any questions on that? I'm happy to answer them. Starting January 1st, just so you're aware, there is pending legislation that was approved by both houses for governor's signature regarding changes to Bagley-Keene again that will go into effect in January. But we will be, evaluating those changes and figure out how they apply to COPRAC starting in the new year.
I can say Bagley-Keene is the thing I'm going to miss most about being on the committee.
Makes sense. A quick update on the civility related rules. So as you should all recall, there were proposed amendments to the civility oath requiring all licensees to do a one-time declaration affirming their commitment to civility, as well as an ongoing requirement annually to kind of check a box reminding everyone of their commitment to civility. That and changes to the rules of professional conduct related to civility were submitted to the California Supreme Court at the end of August. They've been there about 2.5 weeks, so they're still pending before the Supreme Court. But of course, we will be updating this committee and all licensees if there are changes to their obligations that are approved by the Supreme Court in the next few months. And then the only other thing I want to just alert the committee to, based on their role, is that ABA Model Rule 1.16 was recently changed through Resolution 100. So that may be something that this committee may want to consider in a future meeting, just to look at the changes to 1.16 and consider whether or not those are changes that this committee would like to propose be adopted in some form as part of 1.16 in California. That may be something that we can discuss at the October meeting, which may have some more planning involved, as well as consideration of new opinions and other things. And that's all I have, but happy to answer any questions on any of those things.
Yeah, Erica, I had one question. I think I had read about with the civility. I know there was a pending SB bill relating to I guess it was maybe it's reporting misconduct that I'm thinking of. And I think that basically died, is my understanding, other than a small portion that was carried over to the fee bill about like treason against the government. But is that your understanding as well? I just wanted to understand what happened to that parallel bill to our.
Yeah. Sarah, you're correct. So the parallel bill that would have been essentially what is ABA Model Rule 8.3 adopted in California after the California Supreme Court approved Rule 8.3, which is now in effect as of August 1st. That bill did not progress. And so what did progress is some statutory language changes within the Business and Professions Code that do require attorneys to report essentially treason and those types of crimes. And it's a much a limited thing that must be reported, but there's much narrower exceptions to it. So there's really those ABA exceptions that would require reporting. So as we are educating attorneys on 8.3 obligations currently, we're describing the new rule of professional conduct, but also alerting them to that pending legislation that now that the bill has passed through both houses, it's likely to go into effect starting in January.
Are we going to give some MCLE courses on how to identify treason?
Probably not. That may be a legal question, but we are certainly flagging that as an obligation as we are educating lawyers on Rule 8.3.
Okay.
That being said, 8.3 and anything that comes from it is probably something we should cover in the symposium this coming year.
Yeah. Good point.
Yeah, plus there are several new CLE requirements too that I think we should address potentially as part of the symposium. I did have another question about Rule 8.3 because I did review some of which I thought was helpful, the state bar frequently asked questions. And the one addresses the effective date of the rule, even though and I think that was one of the issues raised, I believe, through the public comment period too, is that although the rule becomes effective, I'm blanking on the date. Is it effective
August
now?
1st. Yeah, it's
August
effective
1st.
now.
August 1st, but if the attorney had knowledge prior, my understanding from the frequently asked question is that the attorney had knowledge prior to August 1st, it says, of conduct that would require reporting would still be required because the knowledge exists as of today. So like potentially that means like it could go back, many, many years ago is my interpretation of that frequently asked question, but I didn't know if you could provide any more insight. As long as you have knowledge today, regardless of when the conduct occurred.
Yeah, I can to some extent. So that's certainly, the position that's in the FAQ, and I think that's the most risk averse way of looking at it. Certainly, I have heard just anecdotally that others that are teaching 8.3 do not have the same interpretation of it. But from an education perspective, that is how we're teaching it. So we are telling individuals that you don't, knowledge is not something that you just immediately have a blank slate on. The board and the Supreme Court both saw and evaluated the public comment on this issue. I think CLA was one of the groups, among others, that suggested that the knowledge requirement, as well as the duty to report, applied prospectively from the effective date of the rule. It was raised at the board discussions as something to consider, as well as in the Supreme Court submission materials, and both rejected that as something to be clarified in the rule. So, one might think that since it was raised and rejected that they agree with that interpretation, but that's not something I could speak to, obviously, on their behalf.
Yeah, no, that's helpful. Thank you, Erica. And I see Joel has his hand raised and so does Raquel. So if you want to start, Joel, I think I saw yours first, but I'm not sure.
Well, just real quick, in that discussion, was there any reference to the statute of limitations, the 5-year rule on a 5-year statute on rule violations, or does it just go back to the beginning of time according to the current discussion?
So I think, you're looking at several factors. Certainly the rule of limitations, it's a rule as opposed to statute as it relates to state bar discipline. But the rule of limitations, I think, is relevant for those of you that are involved in attorney discipline matters. That rule has many, many exceptions and tolling provisions. So that's, I think, something that, is beyond the scope and has to be evaluated on a case-by-case basis. But certainly it was, the board, OCTC, and others looking at really what the mission and goal of 8.3 is, which is public protection, and determining that it does make more sense to not have the knowledge requirements start August 1st because there is misconduct that they may think appropriate to report based on what 8.3 says that occurred prior to August 1st of this year.
Thank you.
And Raquel?
Yes, Erica, I know there was a 8.3 educational session, at least one. And so I was wanting you to give us an update as to how it went, how many people were there, et cetera, et cetera. And then you said something that I realized I'm not clear about if it's an issue, which is some people are teaching one thing about this idea that it goes back, but we're, as the state bar, saying it's X. Did I understand you to be saying that in that way?
Yeah, that's my understanding. So I have not personally sat in any of those other MCLE programs. Myself and another member of the Office of Professional Conduct and our Chief Trial Counsel have done a few MCLEs, and I'll describe the details of those in just a minute. But I have heard anecdotally that others are teaching the MCLE, a MCLE on Rule 8.3, and are, aware of the FAQ and other things and have a different position or interpretation of retroactivity of Rule 8.3. So maybe describing it differently in that educational event. And this is something that, likely will be eventually litigated, assuming that the 8.3 case goes to the state bar court and onto the Supreme Court at some time.
So I guess that seems concerning. I mean, are they doing it on our behalf? I mean, why
No.
are we saying, okay, so,
Yeah,
but it
not on our
seems,
behalf.
so doesn't it not seem if we are the arbiter of what is accurate, that we should be making sure they're not teaching what is not the rule?
I'm not sure we have that power or authority to tell people what they can or can't say in that program.
Well, they don't seem to be teaching the rule. I mean, right? If you have a rule, you can't say like, well, let me teach you something that's not the rule. Like that doesn't. So I don't know sort of how this apparatus works, but it seems like that's a problem from the get-go. Like
Sure.
that like we know that's gonna be trouble because it's already starting off on the different feet, right? So I just register that having heard what you say.
Understood.
Over. Yeah, over.
As to the program, so we've done 2 state bar hosted MCLE programs on 8.3. They've been really well received. I think we had about 500 attendees at each, and they've both been on Zoom. Had a lot of interesting questions that came in during them and after them, and we got really good feedback on both. There's a ton of hypotheticals that are presented and addressed in the MCLEs, which have been, I think, helpful. We have one more scheduled for the September 27th, I believe, the last Wednesday of the month. And then we are also doing kind of other outreach. So certain groups have asked for us to speak on 8.3, and we have been doing that as well.
Thank you. I did attend and I thought it was informative. So I did attend, but I couldn't tell how many people were at the one I attended. So 500, I think that's good. Over.
Yeah, good for an MCLE. There's a lot of attorneys that need to know about the rule though. So small in the grand scheme of things, but for an MCLE, we thought it was pretty well attended.
And Chris, so I'd say one other question, because I know you've, I think you mentioned you're going to be doing some outreach too regarding any civility changes, but those are still right now pending with the California Supreme Court, right?
That's correct.
Okay.
Yeah. Let me back up too and just say one more thing about 8.3. We did create a toolkit too. So if anyone is interested in teaching 8.3 themselves, there are pre-prepared slides and kind of a lesson plan that someone can go through. Certainly things that could be used for the symposium, probably adapted for the symposium because it's, several months away still and there may be changes or just more to talk about in that time frame. But if anyone, is interested in speaking to like a local bar association or frankly anywhere, that does exist for people to utilize. Sarah, to the civility, you're correct. So the rules themselves are pending before the California Supreme Court currently, so there have been no changes to those. Regardless of whether there are changes to the rules of professional conduct, the Board of Trustees did approve the 1 hour requirement for 1 hour of MCLE on civility in the legal profession. That rule is effective October 1st, and it would not apply until those with the MCLE reporting deadline of I think it's technically February 1st, 2025. So it's not for those who report this year or this coming year, but the year after that, to give MCLE providers and others time to, create courses and get licensees educated in that area.
And for the requirements, does it, and I should know this, but I know that one of the goals was to have, there be some focus on the link between civility and bias. But as far as, I don't think that's an explicit requirement of the CLE, it's just to address civility, although probably that would be a good part to include if you're doing training, but right now, as the rule stands, I think it's just civility, right, as opposed to civility and bias.
That's correct. Yeah, I would agree with you that I think that would be a good way to teach it, but that's all that's required is civility in the legal profession.
Okay, thank you. Were there any other questions on the staff report update?
I just wanted to add something if there aren't any others, just on behalf of staff and the leadership at the bar. I just wanted to thank you, Sarah and Ken, and all of you for all of your hard work this year. It has been a lot. We know that the board has asked a lot of you kind of outside of your normal ways of working in your ethics opinions. And I just want to recognize how much work you put in and really taken very thoughtful consideration and put in a lot of time and effort on all of these things, 8.3 especially, and all of the AI work that people are doing. The working group I know is working very hard on this stuff and thinking very carefully and critically about it. So I did just want to take a minute to thank all of you, especially those of you who are going to be rotating off. And I hope you continue to stay involved some way or another with us at the bar. So thanks very much.
All right. Thank you, Bridget. And sorry, I lost track of where I am on the agenda now. I think actually that's a good lead-in because our next discussion is on an update from our AI working group. So I think that's going to be led by Brandon.
I will start out and then I will quickly try to pass the baton to Erica, who's done a lot of the heavy lifting. So we've had working group meetings, and with the remarkable work and assistance of staff have begun sort of an outlining of AI related ethical duties, dangers, things like that. And so that was included in the materials, and staff did a wonderful job on that. And we've been sort of revising, modifying, trying to tweak that. I don't know, should we share screen, Erica? I'm not sure the best way to go about that, but our idea was, this is a very new, quickly evolving and overwhelming topic. And the board wants something from us in about 2 months. So, and of course, since we're all computer scientists, that is no problem. And we thought this was a really good framework for a first step for COPRAC to make a statement about the use of AI in the law. And we're just trying to frame it all in terms of duties that are impacted. And the challenges that we're dealing with here are so multifaceted. You know, it occurs to me that a lot of my concerns are aimed at people that are going to use this technology with with insufficient oversight, insufficient caution, insufficient care, and attorney attention. But I'm learning through the working group of this entirely super highly developed technical aspect that more sophisticated and resource heavy law firms are using for AI, which is really not going to address, it's not going to give rise to any of my competency issues, but gives rise to a whole host of other issues in terms of data security and other things. Very hard to come up with guidelines and principles that are really going to capture everything. But that's what we've been trying to do. We have some people on our working group who are not members of the full committee who are really immersed in AI and other computer technologies in the practice of law as well, that have been weighing in and been very, very helpful. So this is our first pass at something we think we want to, share to the group here, because we only have this meeting and the October meeting before we're supposed to hand something over to the trustees. And these are our first steps. So with that, I will sort of turn it to Erica to start guiding us through the document, if that's all right.
Sure, and I'll just add, so at our last meeting in July, for just a bit of a refresher for those who have had a lot happen since then, we had, several, technologists and founders and so forth come and speak to us on different generative AI products. So we had, Winston Weinberg from Harvey, Dorna Moini from Gavel. We had Daza Greenwood, who is one of the working group members from MIT. I'm missing Josh Kavicki, and there might have been one more, but that could be it.
Nima.
Yeah, and Nima, who is part of the working group. I don't think he spoke at the meeting, but
Right.
or as a presenter, but was obviously participating as well. So as you go through this document, you may see some initials you're not familiar with. DG is Daza and NM is Nima. And they're hopefully going to try and join this conversation today to the extent it works with their schedules. But this is really based off of COPRAC's, direction at the end of that meeting, which was to develop something somewhat similar to the MIT guidelines, right? So those are basically what this is, but for the California applicable authorities. So you'll see the rules of professional conduct and some California specific statutes and other rules that have been brought in here, as well as a little bit of federal law. So that's kind of the starting point from which we came from. I think the benefit of having the full committee here is that, we can certainly walk through each thing, but it may be more productive to have like a bigger picture conversation to see where the committee wants to go as far as, are there other rules that need to be addressed in these guidelines? Do we even want a guidelines type document like this? And then as you go through the document, there is one draft scenario that I'll just say, I think me speaking for the working group, so who knows if this is accurate or not. I think some people thought the use of a scenario, I think many people think using a scenario does make sense in the guidelines, not the scenario that you see here. So, there were some concerns, my own personal concerns and other members of the working group, that this scenario is just something that's going to be, copied and pasted into a lot of retention agreements, and we're not sure that this is the best thing to go into a retention agreement. And so it was just coming up with something to kind of take a look at as a starting point. Eleanor had a lot of really good ideas at the working group level to talk about how to kind of come up with some scenarios, and that's what you'll see in that issues list for scenarios as you scroll through the document as well. So that's just a little more context to what you're seeing today. And then, I think I can answer any other questions. Otherwise, I think it may just make sense to open it up to discussion.
I would like to add something that was my offer that I did not see in the document. So I don't know if it was I'm thinking it was just maybe an oversight, which was I felt that this document needs a narrative to go on the front of it. Because I think we're talking to people who don't know anything about the field, which generated their saying, hey, come up with something very specific. And so it sort of frames the contextualization of what this field is. And so there are some things that Erica just mentioned in the back where it talked about, I think it was the last page, it talked about, the usage, the difference between something that's customized, it doesn't use customize in there, but customized solution versus just the general GPT chat. The idea that the application can be front of the house, which is in the practice of the law, or back of the house, which is in the administration of a law firm. And so sort of contextualizing it so that they are thinking more broader and with more depth about really the scope of what we're talking about. And so I offered to draft something, not for this meeting, given the time. And that would be my intent. Whether or not we end up using it was not, that wasn't the point at that point. But just to say, when I look at this and I think about who we're giving it to and all the dialogue and learning we had, it could use something that is more of a frame on it. And on also not just on the fear side, but also on the top side of how can it add to the practice of law? And what are some of the implications that we could, as a bar, be proactive about? Because as Brandon talked about some of the ways it could be misused, what we know is we could probably at some point be more involved with law schools, because this is gonna come to their door. So how should we be thinking about how whatever influence we have, and I say influence, not rules, but influence in how is this going to be integrated, for example, into curriculum? Not a today's issue, but something that if this technology is here with us, it should certainly be impacting how lawyers are going to be educated. So a range of things, but on top, over.
Yeah, I think we all thought that was a very good idea, Raquel. And we just knew there wasn't enough time for this meeting, but I do think some sort of intro executive summary, something to help steer the reader, prepare the reader for what we're addressing and why. I think we all think that's a great idea. We're really battling some time issues here. COPRAC's not known for its fantastic speed. So, you know, I have, to me, I think in a perfect world, we develop scenarios, we do all sorts of things. And I'm sort of viewing this as a step-by-step incremental process. Like maybe we start with our rules chart. If we think we have scenarios in good shape, we can also consider submitting those in November. But you know, by no means is this going to be like this is like the first thing we're going to do on AI. I think we're going to have plenty to do for the foreseeable future on AI.
So just so I understand with this, I'm not clear, and maybe this was made clearer, but I just missed it, on how these scenarios are going to be used. Is it going to be kind of, because right now it's just a scenario. We're not providing kind of, I don't think the intent is to do an ethics opinion. Is it more to be like a hypothetical type for education purposes, or what's the goal with the scenarios?
We're not 100% clear or aligned on the goal for the scenarios. They are going to show ways people might make proper disclosures and get proper client consent to use AI. My thinking is probably we keep the duty chart standalone as the first step, and maybe we do full ethics opinions and use scenarios like we always have done, but there might be other ways we can use them too. We're not sure yet. We have a really the deadline on our mandate from the trustees is the only thing that's crystal clear. So the rest of it is not as clear to us as to what they're asking for. So we've got a lot of leeway there. I apologize. I'll be right back.
Okay.
Sarah, I think I'm thinking about it in much the same way you are. It's just hypotheticals, like just to kind of illuminate issues.
Okay, yeah, that's helpful. And I actually thought the way the state bar did that with rule 8.3, like the education and the hypotheticals they provided, and then an analysis following the hypotheticals, I thought that was very useful. And maybe that's something similar that, I mean, it sounds like that you had in mind with this.
In my view, this document, which includes the idea of scenarios, as Erica said, may or may not be this one, I'm thinking of it to the trustees for their consumption, which is primarily education, because it's not something they're saying that they are doing any learning on. And so I'm not seeing it like, oh, they would then take this as it is and socialize it externally in any way. It's really that's how I'm seeing it so far based on what we have done. I think that is based on the feedback that we would get from the committee today. I think that would then help us as a committee be able to get more focused on, okay, what is it we're trying to provide them and why? And that I think would then shape, you know, should scenarios come in or out. So to me right now, I think we're just have a lot of things on the table, if you will. But I'm not sure we've gone back and said, okay, well, what are we trying to do? Yes, they gave us a question, but at this stage, what's the first step? You know, is it primarily education for them as to just the broadness of the whole topic? So that's where I was seeing it, Sarah. And so in this case, the scenario was meant to say to somebody who doesn't know very much about this topic, we gave you some technical thing. Now here's the practice of it in real life so that they could make the leap between theory to practice. But I've said more on it than we have said as a committee about that. So so I think, you know, thus is still open.
I'll just add, I think that scenarios as opposed to a traditional ethics opinion, you know, having done the 8.3 like hypo scenario type thing versus what we normally see in a COPRAC ethics opinion, this topic at least from my perspective, may be better suited for those types of hypos that are more discrete issues. Often the ethics opinions have, a narrower focus than tell me everything about generative AI and the practice of law, right? We're usually focused on kind of a more discrete issue. This is going to be, I think, challenging from in an ethics opinion format to address everything you need to know about generative AI and how it applies to your professional responsibility obligations. Addressing very piecemeal things, kind of in what was proposed as far as like the deployment model, the usage type, and the legal process, I think makes a lot more sense. So you could address like someone using a Harvey-like product, right? And what they need to consider versus using a ChatGPT type product and kind of the gamut in between there. Similarly, like using it for, a brief or using it to review a contract. There's just so many different, drafting an email. There are so many different ways that it can be utilized. And I think so really breaking it down more narrowly into those types of hypos may make sense here.
Yeah, certainly makes sense to me. Joel, I see you have your hand raised.
Yeah, that was my concern, is that I'm not sure we know enough yet to get into specific hypotheticals. Normally, when we're down the road on a rule or an issue and we know pretty well what our rules are, we test them with hypotheticals. I don't think we're at a point where we know what we're going to have as the rules yet, or if we need rules and how we're going to test them. So I'd like to see us first focused on getting our arms around what it all is and what rules might be obvious to us, and then worry about testing them with hypotheticals.
Joel, I think that's kind of the direction we took in the meeting. We decided to back away from the as drafted hypothetical and kind of turn to an issues list for hypotheticals, which would actually help us with the rule formation. That just focused on, okay, what are the various issues that can come up in practice? What are the different models used by the various providers of this technology, et cetera? So I think we're taking that approach, even though we're doing it a little bit in the context of starting to flesh out issues that might come up in hypotheticals.
Okay, so it sounds like then the working group hasn't then reached a decision yet on whether or not there should be rule changes, although these hypos might help inform that decision. Is that what you're saying?
I think that's fair, although I would say I think several of us are leaning away from rule changes still.
Yeah.
Or that was maybe our initial inclination, and we have not been dissuaded. Yeah, but we're still trying to test it.
Yeah. That makes sense.
Yeah, I would just echo that. I mean, it's early going, but our goal here, our initial thinking is that, we have over a great deal of time and a great deal of effort, have a really robust ethical framework developed that so far seems like it should capture what we need captured based upon our current understanding. It's possible we would ultimately suggest tweaks to comments to some of the rules or things like that. But as this very first step, we're looking at the existing ethical framework and how AI use might interact with it. Give pointers there.
And so I see that November 23rd, we have to have this for the Board of Trustees meeting. So does that effectively mean that by our next meeting, we have to have whatever the recommendation is finalized?
Pretty close to it, I think. We would have to, at our next meeting, it'd have to be close to finalized, and then we can have other tweaks discussed at the next meeting that we implement and provide, but we don't have more runway than that, unfortunately.
Okay, that makes.
I think, what was done with CTAP and civility and other things is there was direction given to staff in the working group. So to the extent it can't be accomplished completely at the October meeting, this group could vote it out and direct staff or the working group or both to take certain actions. The only other alternative is adding another meeting, moving the December, having another meeting. I think our meetings are October 20th and December 2nd. So adding a meeting somewhere in there, which I think might be challenging with just the number of us.
Were there other questions about or comments on the guidelines or hypos?
Not really. I mean, we can walk through each of the rules or ethical duties and our approach. We can talk about our thinking for each. I mean, some of it should speak for itself from the chart that was prepared. You can see comments from different people in the working group. And then we would like guidance from the full committee on, my lean right now would be, we're really just submitting an executive summary and the chart in November, because I don't think we've got the runway to vet all the implications of scenarios yet. That's my sense. But we really want the committee's sense, because other people have different views. Because this is a tough first step into a new area.
I see we have two committee members who have joined, Daza and Nima. So I just acknowledge you to be able to participate. And I echo Brandon's comments. I would find it helpful to be able to hear from everybody, whatever you have on the subject that we could take away. So it could be question, it could be comment, could be, you don't know, whatever, so that we're at least feel like we could have represent and take whatever your comments are into consideration and work through.
That sounds good. And Raquel, just for Daza and Nima, who I think just recently joined us, I'm not sure if you heard the earlier part of our discussion or not, but I just wanted to summarize very briefly. We were talking about both the purpose of these guidelines and the hypothetical scenarios that have been provided. And my understanding is that the working group, although their initial inclination was not to necessarily recommend changes to the rules or tweaks to the comments, that's still not decided fully. And part of the purpose of the hypotheticals or scenarios is to evaluate whether there should be tweaks to the rules or comments perhaps. But at this stage, and given our kind of limited timing that we have, where we have to try to get something near final by our next October meeting, that it looks like we might only be in a position to provide these recommended guidelines and not necessarily include the scenarios. So I think that's kind of just a very high level summary of the discussion that we've been having. But so I welcome any feedback from either of you on thoughts on next steps or just this, the guidelines or scenarios as well.
Yeah, absolutely. Thanks for giving that background. It's helpful, and apologies for being late. I did not get for some reason, I don't know why my calendar wasn't showing this. But I will say that, I mean, I found in general, I find examples or at least applications potentially useful. And I think that they're helpful in this context, but I probably agree, given that just to be on the safe side, to try to keep it more limited to guidelines in the first instance, which we can build on sort of after the October meeting. For what it's worth, I actually think the examples are pretty good in general, and maybe they need a little bit of tweaking here and there, but I actually found them to be pretty good. But yeah, I mean, I think that's a reasonable approach. So we don't go too far out onto a ledge without doing more analysis or thinking.
Okay.
Yeah, and thank you for that background and context. That was useful, and I also find myself in agreement. That sounds like an accurate portrayal of my understanding of where we left things off, and it also sounds like a reasonable path forward. I'm sorry, my name is Daza Greenwood. I'm an advisory member to the working group, and the only slight gloss I might put on it is that I have found while working on basically comparable guidelines through the MIT task force on the responsible use of generative AI for law and law practice that having a fairly detailed understanding of the kind of functional capabilities of the technology and how people would apply the technology to their practice of law is extremely useful to be able to understand which of the rules may apply and how and when, and that task force has been able to do that well short of fully blown scenarios, but we got a lot of mileage out of kind of coming up with what I would call more like little vignettes of sort of like an action or interaction or some decision point that lacks all the context that you would need for like a full legal analysis of the parties and the rights and obligations and all the context. But it really helped us sort of see what things could occur that would have an implication for how it is we would stay in compliance with or possibly risk violating the existing canons of ethics and professional responsibility. So I think there's a little bit of pushing this down into at least small fragments or facets of facts and circumstances that will be important.
Yeah, I agree. I think that makes a lot of sense too, because I think when we just talk about AI without providing what you recommended as kind of a functional analysis of how the technology is actually going to be used, it's not as helpful. And so I do think for that reason, the scenarios are, to the extent we can provide that in the scenarios, that would be great. One other kind of just high level thought I had, and the working group probably already has this in mind, but I think for whatever we submit ultimately to the Board of Trustees following our next meeting as it's refined, it would be helpful to, as I think Raquel recommended already, as part of the executive summary, to include kind of what the working group recommendation is in terms of whether we feel there should be any changes, or if we're just not decided, we could note that too, but whether we feel there should be any changes to the current rules or changes to the comments to the current rules, whether those are necessary. And then kind of just providing a kind of intro of where the working group is at. And if we feel that we need more time and we just aren't decided yet, I think we could note that up front as well. But I think that would be helpful to include in the executive summary that Raquel has suggested. We provide an executive summary, and I do agree with that. But that, and even if the scenarios, I feel that even if the scenarios aren't, fully developed and might need tweaking, it might still be useful to consider including them with the guidelines for the Board of Trustees to consider, because I do feel a little limited by just the time constraints that we've in place. But I agree that the hypos are very helpful. Are there any other comments from other members?
Please.
Raquel? Sorry.
No, I'm just saying, please.
Oh, please.
Please.
Are we going to go over and specifically the various duties? And I don't know how granular you're going to get here, but I just had a question about under the diligence section is, can somebody explain more about what explainability is?
This will be useful because I will explain my understanding of explainability, and then we'll have the people that are actually engaged in the use of AI correct me. But what I was trying to incorporate into both diligence and competence, this idea of explainability, which is not that you understand the neural network of decision, blah, 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 but that the user is able to discern or ask or understand why a particular outcome was produced and not some other outcome. You know what I mean? Like why this affirmative defense, but not this affirmative defense, why this contractual clause, but not this one. In order to assess whether, various options have been weighed, considered, things like that. Because my biggest concern going into this is practitioners who they're going to shut off their brain, stop being lawyers, going to type something in a screen. It came out, and that's my complaint. And what we're trying to talk about is, we don't want that kind of over-reliance. We want attorneys to continue to practice law throughout. The practice of law requires legal reasoning and judgment as to what information is input into the AI.
Mhm.
The questions asked, what comes out, how you test that. And when this stuff is a black box, even if you have the right intention, and I'm worried about people that are not going to have the right intention, they're going to be asleep, right? But even if you have the right intention, it's hard to know whether options that you think might be important as a lawyer were considered and vetted and rejected or just ignored by the program, right? And so explainability has application. It's not a term in AI specific to the law. It is ways in which AI users and developers test the efficiency, the reliability, the usefulness of the programs, error rates, things like that. And I was trying to squish that concept into diligence and competence. I think the use of the word explainability is not going to help anyone. So I will jettison that from now on, because nobody knows what it means, including me, in a technical sense. But that's the concept I was going for, was that I want lawyers to know that their duties of competence and diligence, but maybe just primarily competence, require them to be actively practicing law at all stages of this stuff. And that brings me back to where I was talking about sort of the two levels of AI use. A solo practitioner who might shut off their brain and just output things into the world through AI. And then you've got these really sophisticated law firms that are
like Denton's and
right. They're corralling very specific analytic powers. There's so much competence going on. They have different issues to deal with, but everyone's considering the issues. They've got teams. They've got, so we're really trying to capture all of it as CoPrac, but that was what I meant by explainability. And so we've tried to put that into more useful language in places, and we're still working on that. But that was what I meant there.
Yeah.
Can I ask a question about that? In your mind, how is that different than putting some search terms into Westlaw? You get a list of stuff. Any good lawyer will cross-check that against other things. You don't expect that every case in the universe is present, or that you got the right search terms. Is it just because AI produces a finished product of some sort?
Well, so that's a fantastic question. So there are some differences that are like qualitative. Like if an attorney says, I had my client fill out a form of questions and I've input that into my AI, and here's the complaint, and I'm not doing any more work than that, right? I want to give guidance that is going to be insufficient. If you're not asking bespoke questions to a client or using your legal reasoning. And it's very hard because the point you make is a great one. We're all relying on technology all the time. We are using our judgment as to which aspects of that are, you can just take it and run with it, insert it into your other work and your other judgment, or where you need to double check. And I guess we're trying to underline the fact that you are, as an attorney, required to be involved using legal judgment, legal reasoning through the whole process. I can't give a better answer than that yet, but I really want to, and I want us to in this document.
I think that's a good answer at this point, because it's introductory. So that is a good answer.
Okay.
I think the difference, because that's sort of my query all along as I'm thinking about the field, is that AI, though, has a unique mandate, which is it's mandated to give you an answer, which is why you get hallucinations or wrong answers. Whereas these sort of, when you just do a Google search, you might get a wrong answer, but 9 times out of 10, you're not gonna get a wrong answer, because it's trying to say this is fact, and it's gonna rule out things that aren't. And I think that is the uniqueness that crosses so it gives people the false sense of security that the answer you get is correct, because it's programmed like that is what it's meant to do. That's the way it introduces itself with a level of credibility that really doesn't exist. So it will never come back and not give you. I see Daz's eyes moving. So I don't know what he's thinking. I don't know what I'm saying, but this is what I'm coming to learn. And so thus it'll give you a case to something that really is not the right case, right? But it can't come back and say, I don't have something for that, because that's not what its duty is. And so I think that what makes it more enticing in a way to have someone be just less critical, maybe not because they're lazy. It's just so sort of in some way the way the technology works is that it lures you into a false sense of competence, and so you do have to check it.
That's a great point, Raquel.
I recall, and from that presentation, and I think it might have been Daza who was telling us this example of constructing a brief and then asking AI to construct the arguments against it. And I thought that was a pretty fascinating thought about having it check itself for accuracy. And it got me thinking is that one of the things that we do have to come up with is what are going to be the rules, guidelines, whatever, for checking accuracy of the final product. And I think that's where we need much more technical input, such as we got from Daza in that presentation and from other people. And I think that's an area that we really have to go to before we at least tell the Board of Trustees that's on the horizon of our work product coming up. But verification, and there's got to be ways I certainly don't know, but that we can use it to help us verify.
Wait, so we're
use it.
So we're saying we're going to use AI to fulfill the duty of supervision for the AI?
No, not supervision, just verification.
No, I know.
It
is fascinating, but it kind of leads to the question of how extensive are we going to rely on AI? And that's what we're talking about is, can you, build AI to check its own AI it's kind of a.
Well, Cassidy, I never suggested exclusively.
No. I know.
I saw that as an example.
Yeah, no, and I agree with you. I think it's fascinating, but one of my questions is are we going to get to a point where you're not fulfilling your duty of competence by not using AI, because everybody else is going to be using it. So it just scares me. I don't use it, and I'm going to be a dinosaur.
So
I see that Eleanor's had her hand raised for a little bit, so I wanted to give her an opportunity to speak.
My comments have been covered in part.
Oh, okay.
I'll just add that I think one of the differences, and it's going to vary based on the AI and how it's used. So I think, how is it different than Westlaw was kind of the question. And I think one way that it's obviously different to me is that Westlaw is curated. It's tested. It's a fixed body that it's searching, and there's a lot of money that goes into curating that material, and it's accurate material. You can generally rely on it, and it's accepted. It's well established. So whatever errors might be there are tolerated and probably forgiven by a court. The technology is at that level, like many other AI technologies that are not generative AI, like e-discovery technologies. There's error rates, but litigants accept them for the efficiency. You disclose them, they're accepted. And generally they're lower error rates than human error. So it's gotten to a place where people can rely on it and use it. With generative AI, we're relying on human beings to test it, validate it right now. There isn't enough statistical analysis out there. I think that will change as people start tailoring these to professional uses and using curated bodies of documents, etc. But that to me is one obvious way that we haven't really talked about.
There are, I think it might be important to make a distinction between the different types of AI, because this came up when we had the presentation, and I asked is any of your information being used to train the model? The answer is no. So in many of these models that are used in law firms, Harvey and others, they are much more like Westlaw in my brain than they are like ChatGPT. So there are different types that have, if you just go use the ChatGPT product and put in client specific information, you're doing a lot of things that we wouldn't recommend, right? But if you,
I'm sorry, go ahead.
sorry, if you're using one of the proprietary models that larger firms, the Harvey model or others, that's a closed system, I think.
You still have the issue of validating it and testing it and statistical kind of evidence for.
Daz is shaking his head.
But there's also, I mean, maybe Daz is going to get to this. ChatGPT actually has proprietary stuff now that's closed systems. They don't use your data.
Right.
Like this is evolving so fast that we're not going to be able to. We're going to have to describe the way it works rather than relying on the names of the companies because they're all changing.
Yeah.
Indeed. Well, since my name's been invoked a few times over the last few rounds, I apologize. I do see that there's a hand up, Brandon and others, but if I may, I'll just jump in briefly. Where to begin? So the very first thing I would like to say is a kind of a metaphor that I heard just yesterday for the first time, and I found very clarifying, and I'll share it now. That we're on this question of kind of, I would say broadly, it's what is the technology and how is it the same and different from, for example, Westlaw or LexisNexis, and what are the implications for how we should treat it in this context? And so the metaphor was like with food. So on the one hand, in a modern kitchen, we could have heavily automated tools sort of like a blender and sets of like advanced kitchen equipment. Even in an industrial kitchen, there's a lot of things that are somewhat automated to create like lunch for 5,000 soldiers at a base. That's on the one hand, and that's let's say that's kind of like LexisNexis and Westlaw. On the other hand, imagine a technology that we probably have all been exposed to in popular science fiction, like in Star Trek, they have the replicator, where you walk up to the replicator and you say, Earl Grey, hot, and it just kind of is there. You say, like, give me like a chicken masala with, whatever, some rice on the side, and it just and it provides you the result. You're getting a kind of similar result at the end, and it might be very tempting to sort of combine them. But one of the core differences is you could really kind of like observe and audit like every step of the way of the first process and see how it came to those conclusions. And there may be error rates, to the point that was made on e-discovery and other thing and so forth by Eleanor. And they may be acceptable, but at least we can understand them and what the nature of the error was. Like, was it sort of like, the wrong amount of salt, or was it like, like it's replicated arsenic into here or done something like what is the nature of the error and what does it mean and how do we understand it? How do we prevent it? How do we tweak the system? That's really difficult or all but impossible to do in the same way with the generative AI that's more like the replicator, because we can't interrogate exactly what's happening inside the black box to create the results. So this is important, and I think it's a useful analogy because it means we need to come up with some other ways to evaluate the technology and to come over time to have things like, we can still have statistical models and evaluation benchmarks and things like that. People are in the midst right now of scrambling, is how it feels to me in some of these meetings, to come up with ones that will work, and we're sharing them. There's something out of Stanford called Legal Bench that I've got my eye on, a legal set of benchmarks to evaluate and assess the sort of statistical distribution of the outputs of different major generative AI models against legal reasoning and different tasks similar to what you get in the bar exam, and a set of practical tasks that they've elicited from lawyers. So we'll get there, but we don't. But what that'll do is sort of evaluate the outputs and it's a little bit up in the air now. I think the current state of the technology and where we'll probably be for the next year or so is uncertain, and it's great, and people will and should use it, as I testified to earlier. Although now I guess I'm on the other side of as an advisory member of the committee, but I'm saying the same thing. It's great, but it's just weird and new and different enough now where extra caution is appropriate, especially given that we don't yet have these benchmarks and evaluations, and we're not even sure how wrong it may be sometimes or inappropriate. The only other thing I'd say is the reason I was sort of saying kind of sort of a moment ago is to the subsequent comment on open and closed systems. We should probably do more. Excuse me. Was there a comment? Okay.
Audio glitch, I think.
Oh, very well. I'll just take one more quick moment to say more. The working group, we should do a little more work to come up with maybe a taxonomy of the different, I call it sort of deployment context of the technology, so that we've got better, more accurate categories to describe them in. And I think very broadly, the way people are talking about it is kind of good enough at a very high order of approximation. It's not good enough to make decisions on, and just so we're aware, it's the main thing isn't whether it's open or closed exactly, but it has more to do with what the model is, and then what combination of other technologies and in what sequence the technology is used with. And so there are guardrails and safeguards and protections that occur in some of these more enterprise-facing deployments that have been mentioned, which can maybe take the output and do verification or fact checking or shepherdization and stuff through other channels, and then feed things back in and so forth. We should take a look at all of that and see what the implications are. For purposes of this dialogue, I think we're probably in a good shape to just be aware that there's a rather pure deployment of the technology, like what you would get with ChatGPT or just using the API to OpenAI or Anthropic, that lawyers are using. And that's sort of like the pure case of what's different and what the rules should be. And when there's other safeguards and protections and features and capabilities that people are providing through, like enterprise offerings, I think those need to be looked at more individually and clustered into groups to see how those would change what the advice is. But it's probably not great to start there. First of all, they're chaotic. It's like every company's doing it differently, and they're doing it differently every other week. So it's a moving target. But secondly, it doesn't really tell us what's different about this technology. So those are my comments on that. Thank you.
Thanks. Brandon, did you want to weigh in?
Well, I mean, if anyone wants to respond to Daza, I don't want to interrupt the flow of thoughts there. My other comments are a little more general, so.
Okay.
Daz, I do have a question. So your input, which I will then call throughput and output. So your throughput, your replicator and your coffee machine. That's not what you said, but so does that lack of understanding what's happening in what I call the throughput, which is what's happening in the black box, is that related to Brandon's comment about explainability? We can't explain what's happening in that black box. Is that the analogy of that? Does that word go with what you said, I guess, is the question.
Precisely. Yeah, that was exactly the point I was speaking to. And I found the analogy really helpful because we can have explainability. Like if, like we had the equivalent of a National Transportation Safety Board on, like why my Frappuccino wasn't good yesterday. Like it could get in there and look at everything in the blender and every ingredient and everything and figure out everything that happened and do causality on it and, you name it. But we could not do that in the same way with a replicator. I mean, maybe you could. Obviously, replicators are make believe, but if there's some, but the way this technology is, it's like we literally don't know exactly how it's creating those results. It's sort of there's an improbability sphere. It's non-deterministic, and so we have to come up with different methods, which means it's not so explainable. And I think the implication is really essential for for the broader point that Brandon was raising and that I think we were speaking to, which is what does that mean for how we practice law and how we think? Like, what are we supposed to make of this output? Like, can we trust it or not? And then where do we practice law? So the worst part in my mind, if I may put a quick spin on it, is I have found this stuff to be really good. Just I'm speaking to the California Judges Association a week from today down in San Diego, and I started using one of their bench guides, is what they call them, I think, that help the judges, especially the newer judges, understand sort of like how to do a felony arraignment, this, that, and the other, and they're pretty chunky. So I've been experimenting with one of those bench guides and then being able to talk to the document instead of, memorizing 120 pages. It's doing really good work. I've been playing with it for an hour and I'm getting good answers that I go back and fact check. And it's good. So the problem with this is it's so good. It's like this close to being completely reliable, but it is not completely reliable. So I think the risk is over reliance, if you know what I mean. And then and the only antidote for that I can think of is make sure everyone knows exactly how to practice law. We have our judgment. We have not relied on it. And then we can evaluate its outputs against some other rubric. And I think that's sort of the top, that's the what do you call it, like the tip of the iceberg for like where we need to go much deeper and think through, like, what do we tell people about how to practice law so we never lose our muscles, and so that the new lawyers can gain the right muscles of expertise and judgment, so that we can use the technology well and evaluate what it's doing correctly and incorrectly.
Thanks. And I do have one follow-up on kind of the issues that were discussed. And one is just I do agree with Daza was mentioning about having some sort of categories and definitions. And I realized from Eleanor's comment and Daza's that that's difficult because the technology is constantly changing, but kind of still having a high level description, I think would be helpful for just education to lawyers who are reading this. So I think that would be useful for the working group to consider. And the other question I had is just about the generative AI technologies. And I know you gave the, metaphor to the replicator. And the one question I had for that is, with some of these generative AI technologies, I thought in some instances, at least, the results you're given, there could be sources provided for the results as well. So there would be a way to kind of verify to some extent, although I don't know how all the different generative AI products work, honestly, and how many of them actually do provide, if, for example, you're using it for a contract and provides provision, if it cites to what the underlying source was for that contract provision, for instance. Does anyone, I just wanted to raise that question in terms of verifying.
Well, that, if I may, that kind of dovetails into the comment I was going to make earlier, which is I'm getting the impression, and I don't know whether it's true or not, from a lot of people deeply immersed in AI and in AI application in the law, that the hallucination issue, which is really vivid and understandable, may not be the long-term problem here. The systems are getting better. They are being deployed more effectively in ways I cannot begin to describe, that the instances of hallucination may fade away or be gone over time. However, they are a big deal right now. I mean, you don't want to be citing to cases that don't exist, so that's still a thing. I have a concern that's really, really long-term. I'm not arrogant enough to think that I have a solution, but I have a concern, which is what this does to the standard of practice and attorney competence over time, dovetailing exactly with the over-reliance issue that Daza is talking about. As this stuff gets better, it will be more and more tempting for lawyers to engage in the practice of technology rather than the practice of law, legal reasoning, and analysis. And I don't bring this up from like a guild, I want to protect lawyers' jobs, I don't care about that. Somebody should know how the law works. And most of the members of COPRAC that are practicing attorneys have been practicing long enough that we know how the law works because of how we learned it over time. But this could be a strange and disconcerting process in the years to come if new lawyers are not trained doing their own analysis and legal reasoning. It has long-term implications. And that's why I keep just harping on this concept of competence throughout the process. The lawyer is responsible for the information going in. The lawyer is responsible for making sure all relevant paths that are considered, and the lawyer is responsible for vetting the answers beyond just hallucinations or right or wrong cases. I don't know how to put that in a rule. I don't know how to make a rule help us maintain lawyer competence, but it is what I would like to. It's one of the big goals I would have for what we do as a committee. So I want to speak it out loud so that smarter minds can pitch in or just have it on their radar.
I was going to say one of the challenges quickly is that what I do is, and we do use some AI products, but I don't use any output that I can't reverse engineer the old-fashioned way. But that kind of defeats the purpose of AI. So that doesn't seem like a suitable framework, right? I mean,
I'm not sure.
AI does produce answers, and then it's an idea, and then you have to go figure out whether you can substantiate it. In the same way that if you ask somebody a question on the street, they might produce an answer that was useful for you in some fashion.
You know, what you just said about reverse engineering, certainly in a litigation context, whatever you put out, somebody's going to reverse engineer it for you. And so coming up with rules or guidelines of what you should do before you put it out there sounds like a pretty good idea as a matter of competence.
There's a I don't know if you guys saw this or addressed this before. There's a Texas judge that is requiring, I think it's Texas federal court that's requiring lawyers to, if they're using AI, to certify that it's been backed up by traditional legal research methods. So courts are getting involved and implementing their own guardrails. After that, New York case where they cited the cases that didn't exist. So, that was a big alarm bell. So I haven't seen it anywhere else, but I'm sure that's coming.
There are 2 or 3 jurisdictions, federal and state, where judges are supplementing sort of their requirements, and then there's real questions about how that interacts with like Rule 11 and other things and so forth. So, if I may, there's to your point, Brandon. I did have an idea when you were speaking about how to maybe start to address these things, which is to look at them on a time scale. And so there's some things we know and can say about the kind of current and expected near term, like call it like year or so, maybe, state of the technology that are pretty certain and that do not include people, atrophying how to practice law, that change in the population and our skill base is not on that time scale. And that I agree with you. I think there is a well-identified profound concern about what this means for the longer arc, which could be it could start showing up as soon as 5 years. If you look at, how long does it take to, for an associate to like a new associate to hatch and then to, become like, viable in a courtroom or with a client on their own, and so, but maybe we should look at breaking out, this proposed responses to this technology on the immediate term of like, a year to 18 months-ish or something. And then like the midterm of like, 18 months to, 4 or 5 years. And then maybe, share any speculations or stuff we may have on a longer term so that it can kind of be in the pipeline for the powers that be to consider. And we might be able to make better progress sooner in that way.
I think that's a great idea. So to just to ground this again in what can be accomplished between this month and next month and then handed to the trustees, because as this conversation has vividly illustrated, this is like full employment for legal ethics, like just trying to grasp and then apply legal concepts, ethical concepts to how AI is developing. It's not going to get done this month, right? So what can get done between now and the next meeting? I really think that this chart is a great start. It's building off of great work by the MIT group that Daza is a part of, great work by bar staff, and then we've been doing our best to put good concepts into it. I'm not sure the best way to proceed. Should we take like we should go through any comments anyone has to any of the specific rules in the chart, but maybe, and then get marching orders, things we should work on between now and the next meeting. We will have a revised version of this chart for you for the next meeting. But should we talk generally about what we want to get out the door after the next meeting as the first step? Because I think scenarios are fantastic. I am still very concerned that it's not realistic that we are going to have created and sufficiently vetted multiple scenarios by November. But that's just my thinking. Should we take a straw poll on scenarios, or just so we know what we're working on for the next month, or not? I mean, I don't know.
Can I add one thing to that too?
Yes.
In what I've heard from like Raquel and others, I think we're also looking at two different like executive summary type documents as well. So for two different audiences, one being the Board of Trustees, and like the more traditional thing of like, here's what we did. We met with, we had presentations on generative AI from a variety of people. CoPrac came up with this, and then I think Raquel's mentioned this in a couple different meetings, but like we also recommend that the impact of generative AI is explored as it relates to law students, as it relates to many other areas over which CoPrac doesn't really have any authority. So that's one document, and I would be interested, in addition to what Brandon asked, if there's anywhere that this group thinks anything that executive type summary should address. So if it's, MCLE content, if it's stuff for law schools, etc. So there's that document, and then also basically the executive summary type document, definitions, what have you, for what will actually be seen by the lawyer audience that are trying to take this document and apply it to their practice.
Very good point.
I have a question. Maybe it's probably Eric or staff. Do we know how much time is on the agenda for the trustees for this item? Do we have any idea?
No, I think we will have as much as necessary, but recognizing the trustees' other agenda items. I'll just say that November is typically a pretty heavy meeting for the board, but this is a very important topic. So I think 30-ish minutes is probably realistic if on maybe the short end of it, frankly. But
so okay, so I appreciate that. It occurs to me in having this meeting that the thought was probably is something written to them, but it seems like the best use of time could possibly be some, I don't want to say presentation, but something that's more interactive, because I think that any document is one-dimensional, and I think it just, for people who are just coming in cold, I think it does them a disservice. I think the point Brandon made, he came at it a little different than what I'm going to say. But I think they need to understand that this AI has the potential to be transformative to the practice of law. And that these rules are interesting, and that's sort of the technical down in the details, but that they really, our biggest service to them is to be able to have them appreciate that, because this cuts across everything. And rules are interesting, but this is much bigger than the rules. And so it just occurred to me in listening to what I'm hearing, oh, I wonder, I think staff maybe presents it, but I realize I'm not sure how this actually would play out. But more than 50% be some real engagement for which then they have a document. So I don't mean engagement where we're going over something that's written, but really so they can have the nuances. Because my sense is giving them any kind of just document that's just presented to them, I think misses the real opportunity, which is, guys, wake up. This is a this could be a transformative opportunity. And we should be ahead of this and be very proactive. And this is not, in some way, this is not committee work, because this really, if it's transformative to the practice of law, they need to strap in and start thinking about this in a much different way. And I see lots of ways in which it can be very beneficial. So I'm less on the, oh, it could be harmful. But somebody needs to be thinking about that side. So that was my question about the agenda item, which just came to me as I'm hearing this dialogue. Over.
And I think Erica can speak more on that in response to your comment, but my understanding is that, Erica, you would likely be the one presenting, so it wouldn't just be presenting the document, but you'd be kind of presenting it and explaining kind of the COPRAC, considerate issues that we've been talking about. Is that right?
That's correct. And, there have been times we can kind of maybe talk about this at the working group level as well, but there are times where, we have people that are not just staff that come in and speak. So to the extent, I don't know, Brandon or whoever from COPRAC who's been on the working group and who, wants to speak at the board level, that's certainly something that we could explore as well, to kind of give that more holistic picture of what COPRAC has looked at, the context of what COPRAC has looked at, as it relates to generative AI more broadly, and how narrow kind of the focus is, and maybe it needs to be, zoomed out. So that's certainly something as well. But yeah, Raquel, to your point, like, we typically at the board level, staff does present, but it's not just, walking them through a document for the most part. It's kind of like how we got to where we are, those types of conversations, in addition to here's what's being proposed. We assume that everyone has read what the written document and can ask questions about it if they have them, excuse me.
One of those outside questions that keeps coming into my mind is we talk about regulating lawyers using AI, but to me, it's not going to be very long. It's already happening that it's really going to be non-lawyers using AI, which is like a legal brain in a box. And to what extent, all of these rules apply to licensed people. That is outside the lab, right?
It's happening now. There are entities out there that are pretending to be lawyers and using AI to file briefs and that sort of thing. I've come across it in my practice, and it's just, the courts don't know what to do with it, I think. But yeah, no, it's just going to be more sophisticated as time goes on.
Well, and it's a really huge issue, but it's not, strangely, I don't think it's an attorney ethics issue. Like, the pro se litigant who uses whatever resources are at their disposal. I don't know who gets to regulate that person, right? And it might provide enormous benefit to a lot of people that have access to justice issues. It could also create horrible havoc. But again, bar regulates lawyers. We deal with legal ethics. I think you've identified a super important issue. Who gets to talk about it,
One other thing to consider, I don't know if this has come up, but I heard about it recently, is that certain large corporations, so clients, are using AI to generate drafts and providing them to outside counsel to review and edit. And that's something we might want to just be aware of and think about when this comes from a client. What's the lawyer's obligation?
Wow. Well, fascinating. The ABA just modified Rule 1.16 to require attorneys to exercise diligence throughout the representation to make sure they're not assisting the client with anything unlawful. Really interesting. It really ups the ante when the client's writing a brief and saying, here, file this, right?
check it and file it. Don't spend a lot of time.
You don't spend any time on it. Yeah.
Imagine that, right?
Wow.
So I think just to move us forward, because maybe we should go forward with what Brandon suggested earlier, in terms of getting any additional feedback on the guidelines themselves, and then taking a straw poll on next steps. So I wanted to just see if anyone else has comments on the guidelines or suggested additions or edits.
There's one area that I was interested in hearing other people's feedback on. I think it's a rule. I don't know which one it is though. But it's related to how much do you have to disclose that AI is being used? And I'm curious the range of people's thoughts on that. So it was in the document. I just don't remember exactly which rule.
Scroll
Yeah.
up. Yeah, there. You're talking to the client, not the court, correct?
Yes, yes. So how much, and there was a range of thoughts on our working group about that, as to how much disclosure, and I guess I'll say a little bit more context. The more sophisticated the client, the more they may expect. The less sophisticated the client, the more it might not occur to them all the nuances of the implications. And so therefore, sort of what are people's thoughts in from the idea of the bar saying we're very big on the duty to protect? No thoughts.
Well, I have one thought, if I may. This is, I think I mentioned earlier that this has been a third rail in the MIT context where we've gotten, I don't think there's any proposed principle that we've gotten more feedback on than what we originally called duty for the requirement for consent, which really activated the immune system of a lot of firms and others who just felt like that was going way too far and that was disproportionate and a whole bunch of other things. And some people don't even think notification and informing people needs to be particularly stringent of a requirement. To me, as I'm looking at this, it occurs to me that I don't know, I almost call it a matter of policy, or how to be a good regulator, that maybe this is sort of should be looked at as a lever, as a dial in a sense. And so the less comfortable in a few months COPRAC and the working group is with how good a job we've done, if I can put it that way, of making sure everything's going to be really well regulated, and the more we should turn the dial up closer to consent, as sort of almost an escape valve, because consent is sort of like the ultimate antiseptic to a whole range of things that are going to be hard to foresee up front. And the more comfortable we are that we kind of got this figured out, we feel good about how things are going, the less we can maybe have the dial from consent going back toward maybe material notification or whatever. So maybe one way to look at it is like a dial, perhaps. The only other thing I'd say is I think I'd mentioned earlier, I'm new to coming back into California in a professional context. I'm not barred in California. So I would just be fascinated to know what the rule is with client consent in general for things. And I think the more detail on that and the more context around how it's been applied, when there's been violations or whatever the rule is, could be really helpful to just look at that and try to extrapolate it to this situation. And I just literally am ignorant as to what the exact rule is at this point.
So I'm not seeing anyone respond to your
Right.
question.
Silence.
I will, so the informed written consent is what you're asking about in California, and that's defined as part of our definitions, but it's applied in different rules, primarily dealing with conflicts of interest. But just so you have it, it's part of, the definition itself is part of Rule 1.0.1. E1, which talks about E first talks about informed consent, means a person's agreement to proposed course of conduct after a lawyer has communicated and explained the relevant circumstances and the material risks, including any actual and reasonably foreseeable adverse consequences of the proposed course of conduct. And then there's a separate definition for informed written consent, which just basically means that those disclosures have to be in writing. And I know, I read that kind of quickly, and that definition is, incorporated into other rules that require informed written consent, primarily those dealing with conflicts of interest. So I'll just pause there in case that was, helpful.
That's really helpful because it tells me we're not going to get much help from that rule, because it seems to relate to advising as to the consequences of taking a course of legal action. And it also, like, the two big features are material and relevant, which is so it's party time in terms of semantics, it sounds like, on the rule. But the other thing is, so maybe a place to look at is agency law. We're fiduciaries as lawyers, and there's a whole, I have got to go back into the crypts and back attic rooms of my mind, but I remember in like restatement of agency and in some other case law, there's some pretty good context on the agent, especially fiduciary agent's duty to keep the principal informed, and but then we also have some degrees of freedom in terms of how we do things when we're independent, contractors or things like that, in terms of our tool choice and stuff. So maybe we could, at some point in the work of the working group, take a closer look at the sort of more general rules of agency, and see if we can get any further help on that in terms of how the agent does the job, as opposed to recommendations on the consequences of taking advice.
Yeah, I think that's a good idea. And I think it's something that we need to consider some more too. I mean, I haven't, looked at the rules kind of with an eye to the issue of that's just been raised about getting kind of informed written consent to the use of AI. So I'd have to look at it a little bit more closely, but I was just kind of giving, a quick answer as to informed consent, and the committees probably, or working groups probably, consider that a little bit more. But so are there any other kind of comments on the, sorry, Joel, if you want to.
Yeah, sorry, I recalled in the course of our research a year or so ago on the costs advisory, the research we did is that the agent is presumed to have the authority to bind the principal to pay for whatever needs to be done in the ordinary course of the agent doing the work, without getting any particular consent. And I would think that if you're using any tool or something like AI, it just wouldn't fit that mold. But that would be something that, if we're going to go that way, we'd have to go back on and look at.
Yeah, and on that point, there are a lot of ethics opinions that exist that I think are useful in the context of the use of, storing confidential client information on the cloud, use of different cloud technology providers. And there's a lot of ethics opinions that talk about, getting the clients, disclosing that to the client, particularly when you're dealing with certain types of client matters where confidentiality is key. So I think those ethics opinions might be useful when we're talking about the issue of disclosures to the clients. But that, yeah. The other, I just wanted to see if there's any other feedback on the guidelines themselves before we go into the straw poll that Brandon had suggested.
And are you asking specifically, Sarah, about feedback on the table, the guidelines that are included with that they go through the various rules. Is that what we're talking about right now?
Yes, and I think Brandon, is that right? That what you wanted to kind of make sure we get the feedback on that?
Yeah, because so the table has text and then it has comments that we are intending to continue to discuss and revise in the text. But if looking for more comments and thoughts on the table itself, then maybe we'll do a straw poll on what we want to focus on for next month of these items.
Well, since I won't get to speak next month, let me just give a high level comment, I guess. I really like the table. I think it's very thoughtful, and these concepts are very challenging and dynamic. And so my big picture comment would be to echo what I see in some of the yellow highlighted comments, which is that some of the statements really could use, as they're refined, more nuance and qualification. Some of them come across as, I think, unintentionally too rigid, and don't build in, I think, as much consideration as we'll want in the final product as to what is, particularly in that third column, what is necessary to comply with the rule, as opposed to kind of what our aspiration is as to what somebody is going to do in order to comply with the rule. And in particular, for me, what stood out was some of the discussion in the duty of competence, and in particular, the discussion about how a lawyer should learn to compose prompts to generate high quality outputs. I think conceptually and aspirationally, something like that makes perfect sense, but it also depends on how someone's using it. If someone is more concerned with critically analyzing their output, and their input is more just playing around to see what they get, and they intend to do something on the back end to make sure that they're not citing cases that don't exist, that's the type of nuance that just that statement in that's as written doesn't take into consideration. So I think as we're drafting these, keep in mind that people will nitpick and maybe look at these things not big picture, but in a granular, rigid way. And I don't think we want to suggest similarly that we're imposing too rigid of a standard at this point. So just in conclusion, because I rambled there a bit, I think we want to look at these and carefully and decide where is it that we should add gloss, nuance, qualification, given how some of these statements as written might ultimately be interpreted. And looking at this from kind of big picture, that we want these guidelines to be applicable as the technology changes, and also not set a bar that is maybe unintentionally too high for practitioners. So that's my big picture comment.
Justin, I agree with literally everything you said, and the challenge is in making it so. But I'm with you
No, that is the
completely.
details. Totally.
Yeah.
Totally agree. I'm sorry I won't be here to.
I'm sorry too. I'm sorry too.
I have a big, there are, in my opinion, and I tried to address some of them at the very bottom of this document, rules and other authorities that maybe aren't in this guideline that may be applicable, maybe things that we want to address in it. It does become very fact specific in some instances, but like conflicts and screening and those types of things, I think for could come into play. And so, advertising rules, maybe you can see all the ones basically with question marks next to them are ones that if anyone, not to put anyone on the spot here, but if you have thoughts on those and think they should be incorporated or shouldn't, I think that would be also helpful.
And Erica, to clarify, you're talking about just the ones listed here that have the question marks? 3.4.
Yeah.
Okay, 4.1. Okay, gotcha.
I think those are the big ones. 8.4.1 is a huge one, right? That's not addressed in here, but maybe it should be, maybe not in the guidelines, but as we've learned and as everyone I think knows, a lot of these systems are trained on biased material that can perpetuate biases. And so to the extent it's relevant to include 8.4.1 in some context, I think that's something that's not contained in this that needs to be addressed. I do also think, depending on the size of the law firm, if you have, clients that are actually or potentially adverse that may have been covered by a conflicts waiver of some kind, but you're putting, especially if you're using a closed system where you feel like you can put more confidential information into it safely, you're mixing it, or you may be mixing it depending upon the system, and that is not addressed by the guidelines currently. Again, very fact specific, but if we're trying to kind of alert lawyers to all of the potential pitfalls of this, it may be something that needs to be included.
All right. Well, it sounds like members don't have immediate feedback, but I do think those are important issues to consider, Erica, and maybe for the working group going forward. And I think particularly, I know it's not with the question mark, but I do think 8.4.1 we should likely incorporate above. But the other ones I'd have to consider some more. I'm not immediately seeing how 3.4 would necessarily apply, but I might be just missing something. But I think this is an issue for the working group to further consider since we don't have any immediate feedback. Anything else on the guidelines that are in the chart that people wanted to weigh in on? Not seeing any. Brandon, do you want to suggest, because we're getting close to the lunch hour, what the straw poll that you would like to take to kind of further guide the working group?
Sure. So as an opening salvo, I would just, my question I want to know is, I would suggest that for next month, we try to polish up the chart and with the executive summaries that Raquel and Erica have talked about, the 2 executive summaries and the chart, try to get that in shape for next month discussion, approval, and to the board, and that we thereafter dive into the scenarios, like a 2-step. So that would be my proposal. And maybe we could just do a straw poll on that versus doing it all at once, you know?
Brandon, when does the thereafter come? How long after?
As soon as we satisfy our obligation to get something to the board in November, we dive right back. I don't see any reason to, I think the AI working group should, plan on a long road of working. So immediately thereafter.
Okay, so I think, Brandon, so are you moving then to take a straw poll on polishing up the guidelines in the chart with the executive summary, sorry, in lieu of addressing the scenarios at this time, and then later addressing the scenarios? I think that's so. Angela, could you maybe do a straw poll on whether the answer to that, if you answer yes, you agree with Brandon's proposal, or no, you'd prefer to address everything all at once, including the scenarios?
Sure. I'll take the poll right now. Bacon? Brown?
All at once.
I'm sorry, Raquel, I didn't hear you.
That's a no vote, right? So no would be to do the scenarios and the summaries and the guidelines together. And yes would be to limit it to just summaries
No.
and guidelines.
No.
Okay. Bradley? Shivers?
Yes.
Krieger?
Yes.
Mark?
Whatever Brandon said.
Mercado? Munoz? O'Reilly?
Yes.
Poindexter? Star?
Yes.
Vanola?
I was gonna vote, but I didn't hear, did Eleanor respond? I didn't hear her response. I'm sorry.
I did not get a response for Eleanor.
Yeah, I thought she was trying to, but maybe on mute. Yeah.
Hear me now?
Yes.
Okay, yeah, I said yes.
Okay, thank you.
Okay, and so I'll vote now, and I also vote yes. Thank you.
Okay, so we have 7 for yes and 1 for no.
I know that was just an informal straw poll, to kind of inform the working group for their next, discussion, but I think with that, we could probably break, it's 12:02. I'd say let's return at 1:05. And just I don't, before we break, I just have a quick question. Brandon, are there other discussions on AI that you think we need to have for the working group after the lunch break, or should we move on to the
I
next?
don't think so, but I want to defer to anyone else in the working group who has other straw poll items or anything else they want to discuss.
That's a good idea. Not seeing anyone with their hand raised, so I think I'll propose that after the lunch break, we'll move on to the next agenda item, which will involve, I think Justin's topic, which is discussion of 20.002, the public comment summary. So, thank you, everyone. I'll see you in about an hour.
Thanks.
Bye.
Okay, well, welcome back, everyone. And Justin, do you want to take the lead with the discussion on the public comments you received on the draft ethics opinion?
Yeah, that's great. So I believe on Tuesday or Wednesday, we had public comments circulated in a table format here, kind of summarizing what we received. And then for purposes of today, I just tried to put together a brief response to some of those comments to give you all some flavor for what my kind of initial reaction was to the comments. There weren't that many, I guess, relatively speaking. I think there were about 7 comments, 2 opposed, and it looks like 5 would approve it if modified. So let me just briefly go through them, because I don't know if you had a chance to take a look at them before today, since I think my response portion only came out maybe a day or 2 ago. If we're able to
Yeah,
publish that.
I'm gonna work on that for some reason. It's not.
If it doesn't project, I can just quickly paraphrase. Well, while we're working on that, I think the bottom line is that the comments, at least from my perspective, were mostly wordsmithing and minor edits. There wasn't anything that I viewed as some kind of game-changing, opinion-altering proposal. So I think we're in pretty good shape for the next team working on this to hopefully quickly knock out some of these edits, and then a decision can be made about it going back to out to public comment. So let's just go through a few of them because there aren't that many. The first, or I guess number 2 here, talked about mechanisms related to training associated with succession planning. And what I commented there is that we already have reference in the opinion to both California State Bar and ABA resources that are online on succession planning. So that's already addressed in the opinion. I don't think that we need to do anything further there unless we decide that maybe we've missed a resource related to training and support that we would want to add, but otherwise it's already in there. The second, or I guess comment number 3 that opposed it was expressing concern, well, maybe this opinion kind of gives differential treatment to long-term versus short-term client relationships. And my response to that is essentially, I don't agree. Whether a lawyer cannot practice law or can is going to be implicated whether it's a short-term relationship or a long-term relationship. So the ethical guidance that we're trying to provide is not just singularly focused on a long-term or short-term attorney-client relationship. It covers both. So I didn't really feel that this comment requires us to change anything. Number 4, provided an attachment with some thoughts about succession planning based on, I guess, his own experience in considering succession planning. He put together like a 2 or 3 page chart that I thought, nicely synthesized some of the issues that relate to succession planning, and it's in the packet of materials we received. And so what my thought there is, since he did put the time and effort in, I guess presumably for his own practice or personal purposes, to draft this, I think we want to take a look at it and just make sure that we feel like we've adequately covered some of these issues and themes that he's spotted and addressed in his own succession planning guide, and then B, also see if there are ways where we might want to refine or wordsmith the same concepts as they appear in our present opinion to make sure we're as clear and clean and crisp as we want to be in our final product, because I thought his outline succeeded in those respects. So I think it's a handy guide as we look at, kind of as a cross check in trying to improve the product if we need to. The fifth opinion or comment about our opinion was more critical. This was from a trust and estates lawyer who expressed, I think, 2 general comments. One is we should address the probate code with respect to lawyers who pass away and the applicable statutes that relate to practice administrators. And then related to that, we use the phrase practice administrator in a way that the commenter thought was not precise, because that phrase, it appears, comes up more in the probate context. And so my response to that is, 1, okay, we can be more precise in how we use the phrase practice administrator. We probably don't need to use it as a synonym for the assisting attorney that we talk about in the opinion, but instead can reference it, in my view, probably in a footnote where we provide the relevant probate codes that may relate to the situation where a lawyer passes away, so that we have those probate code sections there as guidance for the reader to look at, but without, I think, becoming a distraction to the kind of ethical focus of our opinion. But I think it's a fair point for us to plop those probate code sections with a brief discussion, at least in a footnote. And I believe that the one bar association comment we received, or association comment we received, also made that same point, that we should at least reference the probate code. And that takes me to number 6 here from the CLA. Unless I missed it, the CLA was the only organization that provided commentary. And again, relative to prior correspondence we've received from the CLA, I thought that the comments were in general wordsmithing in nature. And at least from my perspective, I think we can and should be open to looking at some of their proposals for wordsmithing, such as how we phrase certain things in the digest, in the introduction. Those seemed fair to consider. There was also discussion in the CLA letter about lawyers with diminished capacity and how that can reflect or affect the ability to practice law. And my reaction to that was, it's a fair point. I personally can't recall if we cross-reference our diminished capacity opinion in our current version of this opinion. If we don't, it seems like a fair point for us to raise that as a cross-reference. But what I would be reluctant to do is delve too far into the weeds of diminished capacity and kind of muddy the focus of our opinion, which I think is pretty clear and short and concise. But it may deserve a cross-reference on that particular issue. And then I think the final comment that stood out to me from the CLA was some tweaks to the scenarios and how we emphasize certain rules or do not emphasize certain rules in the discussion therein. My gut reaction, and for the committee to think about for the next iteration, is I'm not terribly keen on making too many modifications to the scenarios based on the feedback. The reason being that the rules speak for themselves. They're already quoted in large part in the opinion themselves, and it may create duplication and distract from the points that we're trying to make in an efficient way. So I just don't think that those particular suggestions from the CLA were as helpful as maybe some of the other ones. And then the last comment was just for us to change the date of a case, which is one of the most minor comments, but correct comments that I've seen in 6 years on this committee. So that's a summary, as quick as I can, of what we received. It seems pretty minimal and straightforward to me, and so hopefully we can take this feedback and with some minor edits, have this in good shape for either a further comment period or whatever might come. So that's my my reaction, and I guess at this point maybe I'll open it to any other comments that you all have about either the public comments or where you feel the opinion is or might require substantive change.
I'll ask a question. Justin, who are the other working group members on this one? Do you know?
I don't remember.
I reviewed it.
Okay.
Officially.
Depending on other committee members' feedback, I think as we've kind of talked about at other meetings, my office's staff is open to assisting COPRAC in some of their opinions to move them along. And since this is a, complete opinion with relatively minimal public comment, assuming that this group agrees with Justin's approach on the public comment, I think that's certainly something that staff could at least take an initial draft at updating to reflect the comments, and then circulating to the drafting group. So just want to present that as an option for this opinion.
Sounds more like an opportunity than an option to me, which sounds great, but is that something we would vote on, or how would you propose approaching your
approach?
Your option?
No, I think that that's just fine. If the working group is comfortable with that, staff can certainly do that. It would still have to go through every channel, right? So it would be revised, go to the working group for further edits, if any, and then obviously go to the committee. But maybe that could move it along relatively quickly to either the October meeting or the December meeting.
And Angela, are you able to confirm who's on this working group? Because I was since this will be Justin's last meeting, I just want to make sure we have enough people left on.
Yes, let me check.
I was technically on it, but quite frankly, Justin's been doing all the work.
So both of you will be gone then. So yeah, so we might need someone new but maybe there's still someone left. I'm just not sure.
It's Joel, Mark, Ken Bacon, and Justin Jones.
Okay, so Joel is the remaining member. So do you think, should we have one other person assigned, or you think with Erica, with the staff and Joel's assistance, we can kind of try to finalize it? What is everyone's thought?
I'd be happy to help with it if you want another person. I read it once already.
That sounds great. That way we have at least 2 people in the working group to kind of finalize this along with staff. And Raquel, I see your hand raised. Do you have a question or comment?
I have a question from, I guess, Justin, since he's speaking. Do you have a recommendation whether it should be moving towards the trustees or moving back out for a second public comment?
Well, that won't be my decision to make. I think it depends on how this typically works. It depends on the nature and scope of the ultimate edits that we make, and then we usually get the feedback from State Bar staff about their view, and then we make an informed decision. So I think it's premature to say how this will play out. I think we should see how the edits look, and then we can make that informed choice. But I think that whether it goes out for public comment again or directly to the State Bar for voting out, this is, it seems very close, one way or the other, and the edits here, I think, are relatively minimal compared to what we have had to do with other opinions. So I think we're in good shape regardless.
Okay, so that was the basis of my question, based on the way you presented it, and I did read everything. That was why I was asking you, what did you think? Because you basically thought it's more wordsmithing and maybe just crossing a few T's to see if we got some things, whether probate or the succession planning graph. So that's why I was asking you the question, because of the way you presented it. I realize we're not going to be the final decider, but in your view, and I'm sticking to you because it seems like you were handling it. So I understood your answer. And based on his answer, I don't know. It does, I mean, it seems like it's more, I'm not sure sending it back out does anything else other than concerned about the small sample size of people who are committing, knowing that there are associations that are representing larger groups of people, but it's still a very small sample size. But I think that's a underlying issue on many of the things we sent out for comment.
Now, as someone now who have to get back into this, reading over it, I think Justin's comment is absolutely correct. It would depend upon how extensive they are. And I think we just take a look at this. I don't see them as being all that extensive based on my one reading of all these, but well, the time to make that decision is at the next meeting. And although we won't have Justin's comments and guidance then, I think we have it now. And so let's make the changes and take it up at the next meeting would be my thought.
So in terms of making the sort of first crack edits, are we all kind of on board with staff taking the first crack, and then subject to their timing, there may or may not be an opportunity for the working group to provide their further input for the next meeting?
I'm comfortable with it. But I think we can also turn around comments pretty quickly. They're not extensive changes.
Yeah, I'll commit to do it as long as staff, turn it around as soon as I can, as soon as staff gets the first cut. I'm sure we can get it done.
All right. Well, good luck. And of course, thanks to Dina for doing much of the legwork, with the first go round. So. That's all I got.
So were there any other kind of comments from the group? Because I think we have an action plan then, and can move on to the next agenda item, but I just want to make sure if anyone else had any thoughts on the public comments. Okay, so not hearing anyone, I'm going to move on to the next item on the agenda, which is the discussion of the revised memo and revised opinion on conversion clauses. And I believe, Joel, are you the one taking the lead on that, or is it
Brandon?
I'll say a quick word and then pass it to Joel, because Joel's done the heavy lifting since the last meeting. And I will just say we've had a couple timing issues because we've done a pretty major revision based upon the comments and direction from the last committee meeting. Joel's done all the work, but the drafting team has not really, the timing didn't work right. And I apologize for that. We didn't get to coordinate that well. And where in other circumstances, we might have held this for another meeting before submitting it, we really wanted to give Justin and Ken the opportunity to be heard on this because they've worked on this and commented on this, for years. And we thought it would be terribly unfair to make all these revisions the meeting after they depart and not hear from them. So, and then I'll pass it to Joel now because Joel did the work. And I'll let Joel describe what the approach was.
Yeah, I, after the last meeting, I stepped back and decided we really have to take a complete new look at this and just see if we've got it right. And I read all the law review articles, I read all of the cases cited from out of jurisdiction, and I summarized my thoughts and conclusions now in the revised recommendation. And then there was only one or two even hypothetical uh, thoughts about how you might have a conversion clause that was anything other than um, just the reasonable value. And what I decided to do, that was the one in the Colorado opinion. And I decided that okay, let's check those against California case law. And so I went to the California Supreme Court case of Fracassi. And in the course of studying it, a lot deeper than I ever had, I realized that um, the subconscious conclusion that I had is probably correct, that you just cannot have a conversion clause that's going to pass muster under Fracassi, and for several reasons. Fracassi says that at the end of the day, the first attorney, assuming only a two-attorney situation, the first attorney who's terminated for any reason, especially after the Shepard-Mullen case, is limited to the reasonable value. And that Fracassi concludes is fair and adequate compensation for the first attorney's services up until the time that they are terminated. What Fracassi goes on to say is that at the time of termination, it's impossible to calculate what that reasonable value is, because what is unknown at that point is the outcome. In other words, whether there will be any reasonable value, whether there will be a fee recovered. And secondly, if there is, in the happening of the contingency, there's no way of knowing the relative value of the second attorney to do the determination of what the reasonable value is of the first attorney and compared to the second, and ratio to the second attorney, which the Cazares case says has to be done so that the client doesn't end up paying more than the agreed upon contingent value. And that came home to me on Monday when I was testifying in a attorney versus attorney fee split, and we got into all this. And real briefly, it was a case where the first attorney, it didn't involve a conversion clause, but the first attorney was trying to get a PI case, accident case settled, and the insurance company had some complicated upload thing, the only way you could submit proof of the claim. And the first attorney did a mediocre job, but an adequate job of getting all the stuff done, but could never get by this upload process for 4 different attempts, and ended up in a screaming match, if you will, with the insurance company. Client fires the first attorney, the second attorney comes along and takes care of everything and gets a policy limits offer. And so you had to evaluate, it wasn't just the hours, it wasn't just anything, but the point is there's so many variables in these situations that it's impossible to guarantee, if you will, in any kind of formula that you outline, other than strict reliance upon the Fracassi rule, that's going to guarantee that reasonable value is what will be received and what the fee of the first attorney will be limited to. And that just drove home to me that a conversion clause just doesn't work for that purpose, because either you formulate one that does comply with Fracassi, in which case it's entirely superfluous and duplicative, or you don't, in which case the client always has to take the risk upon trying to terminate the relationship. Is how is that going to come out? Is it going to cost me more or not? And that risk by itself is a deterrent to the client's free and unfettered right to terminate the relationship at any time. So I am more than convinced that there just shouldn't be any exceptions. I had hoped, and I don't mean any disrespect, but we had talked about maybe Sarah and Justin giving us some possible scenarios that we could run against this, my thinking. But I tried to come up with some in my own mind, and still I just couldn't, including the one in Colorado, which was the sophisticated client situation. It just doesn't pass muster under Percassi, which is what our Supreme Court has outlined is the formula of how you fairly compensate the first attorney for the services they provide up until the date of termination. And so that's why I suggested the recommendation, and I ran it by our committee as much as I could, that we just adopt the no exceptions opinion, and say that it's just not ethically proper to include it.
And if I can just clarify a couple of things, jumping off of what Joel said, we tried to be very clear. When we say no conversion clauses are permissible, we are defining conversion clause now to be one that purports to entitle a contingent fee attorney to more than a discharged contingency attorney to more than quantum merit. So that's baked into the definition. It's just a different way of stating what we had floated for weeks, months. I don't know. It's been a long time, but you know, this has been a point of contention with the committee as a whole for a long time as to whether a per se prohibition is supportable. And the working group has come to the conclusion that it is. But I know Justin and Sarah have expressed, you know, concern and doubts. And we really pushed this really for this meeting because it would be deeply unfair for Justin, who has been really eloquent on this subject previously, not to get a crack at talking about it.
Is there, I mean, how much consideration's been given to preventing gamesmanship by, attorneys?
By attorneys?
Well, I'm sorry, but yes, attorneys came to mind, and I'll explain my thought. But by clients, but suppose you have an attorney leaving a firm and going to another firm, and so they fire the firm and take the client and want to take the contingency fee. I mean, I can think of so many cases where this would just be grossly unfair, and I don't like the idea of having no discretion.
I understand. Our consideration was that, you know, we got a lot of public comment on the first round that really focused on protecting lawyers from bad faith manipulation by clients. And our view on the working group, not necessarily the full committee, has long been that among the contingent risks you take as a client, as an attorney in a contingency fee representation, is that you'll have a falling out with the client, that you might not be able to progress, whatever, and that the law already builds in appropriate quantum merit protection. We heard from a lot of public commenters who say quantum merit's insufficient protection, and you're still going to get played with, and we disagreed. We thought quantum merit is the protection because every contingent fee attorney has the possibility of getting fired by someone who's trying to settle around you or do this or that, and you have your rights to try to enforce your fee, a reasonable, fair fee. That was our view.
Brandon, Brandon, it was, if I could say, it was more than just us disagreeing. I think the Percassi case disagrees with that conclusion, that you're ever entitled to more than quantum merit. And Eleanor, answering your question, there is the whole line of cases, and I just can't think of them because we didn't research that in this context. But when the attorney withdraws from the firm and takes the cases, the attorney carries with them the fiduciary obligation to account to the prior firm for the value of what they took. And the first firm is entitled to their quantum merit value, and the second attorney has the obligation to account for it. So that's not to say there's always going to be an agreement, but that's something that is for the attorneys to work out, and it shouldn't burden the client. And the problem with a conversion clause is that puts the burden on the client to take the risk of what happens. And so I think that the Verkasi case, if you read it again and again, it's really clear. What you get, your protection for the first attorney is you get your reasonable value. And if it's on the courthouse steps where you've got $1 million offer and the new attorney swoops in and takes it, the Verkasi case and even the Cazares case suggests that you might be entitled, the first attorney might be entitled to 100% as the reasonable value. But the client can't be burdened for any excess. It's for the attorneys to duke it out. And that's why there shouldn't be a client contract issue.
Muted. I would just add too, I don't know about you, but I haven't seen a situation where there's been a conversion clause where, you know, an attorney leaves a firm and goes to another firm. I mean, I don't know if that's a thing.
Yeah, I haven't seen it either.
It happens, but that's usually a matter as between the two firms and their professional relationship, whatever agreements they have. But I can't recall seeing a fee agreement that had a clause of that nature.
Well, I've seen it because it comes up in the context of the first firm getting terminated, just like any other termination.
Can you tell us what you've seen?
Oh.
I'm really interested in like what does the contract read? That
Yeah,
if
so even just in a regular contingency contract, you have a separate agreement and a partnership agreement about what they might do with fees between each other.
right.
From the client's perspective, the first firm is terminated. And so let's say that the departing lawyer, in order to get the client to come, or for whatever other reason, offers a lower contingent fee. And so the client goes, first firm is terminated. To Eleanor's point, quantum merit would be less than they would have gotten. And I happen to agree with Joel and Brandon that it's better for the client to have the quantum merit, but the first firm is getting disadvantaged to some extent.
Sure. And you make a great point, and Eleanor raises a really good one. I have always viewed that as a dispute as among departing lawyer and former firm. And what concerns me would be a contingency clause that says you're hiring this firm, but if you disengage from us to go with the lawyer that's been handling your case for 2 years who departs our firm, you immediately owe all of our hours at our hourly rates. You know, that would be the kind of burden against the client's right to discharge counsel at any time. That's you know.
And maybe that is, and that's Ken's point, I think, which is that we handle it in a partnership agreement. So the attorneys who leave have to, you know, adjust for previous attorney to attorney adjustments, but the client is not paying a different amount or burdened by that in any way. So, I mean, I come down on the quantum merit side for that reason, because it is an attorney-attorney issue, but it does come up in that way.
Well, actually, in the case I testified in on Monday, that's exactly what happened. The first attorney had one of those 30% before the complaint, 40% after the complaint. She ended up filing the complaint 2 days after she got the case, which was subject to criticism. But then the second attorney who finally took it over agreed to do it for 27%. And by the time it all happened, it was only the attorney versus the attorney. The first attorney agreed to take a quantum merit share of the 27%, so the client wouldn't have to pay more. But that was just the way that one came out. But it does come up, I agree. But
There's
still,
parental authority in the partnership agreement or in, you know, between the attorneys in court, not vis-a-vis the client. That's my thought.
Right, and
That's
there's
what I
one.
was getting at. I mean, I haven't seen, that kind of it'd be a weird conversion clause. If you have something in there that the firm might break up or an attorney might leave, and covering that type of situation is probably why I've never seen that, because it's probably not good client relations to include that in your initial fee agreement, but.
Well, it's any kind of termination, right?
Yeah.
That's when it converts. Theoretically.
That's why I don't view that any different than other conversions.
Mhm.
And as long as it, I guess what we're saying is we have no problem with quantum merit. A lot of these other states that we've looked at didn't have an express default to quantum merit where a contingency fee attorney is terminated. And attorneys really could be out in the cold. And other states developed, conversion clauses that say, well, if you fire me, I'm entitled to my reasonable fee. And that had to be analyzed in other jurisdictions. But in California, that is the default protection for those attorneys under the law that we think is sufficient. And to exceed it is to impermissibly burden these client rights to determine how to settle, to determine to terminate counsel at any time. And one thing I just want to note is that we are not sort of stepping on the third rail that I've run into on other committees of saying that the next attorney doesn't have freedom to contract for, we've seen things, I see them all the time where it says, all right, you're firing attorney number one, you're hiring me, and you're going to pay me my third, you take care of attorney number one. I get my own third, right? I find that inappropriate, non-ethical. Lots of people disagree with me and say that's freedom of contract. We're just not touching that. We're talking about the terminated attorney in a contingency representation is limited to quantum merit, and a clause that would purport to entitle that attorney to something more is not permissible.
Have you considered prohibiting such clauses in cases where they do unduly burden? So
I'm having a real hard time hearing you, Eleanor. I don't know if anybody else is having that.
Yeah, unfortunately, it's pretty quiet, Eleanor. Sorry.
sorry, is that better?
A little bit, yeah. Still kind of low, but.
I'm not sure why. I apologize. I'll try to speak up. Have you considered prohibiting such clauses only in cases where they do unduly burden the client's rights? So that there's a little bit of having that be the test. So there's some flexibility.
Well, that
would
was the
protect against the gamesmanship, right?
that was exactly what we had in the first draft, which was saying that these things require intense scrutiny and but what we're unable to do is come up with what appears to be a conversion clause entitling an attorney to more than quantum merit that we think is acceptable. And we just haven't come up with any options that we thought were realistic and permissible. We invite the committee to brainstorm on that, and we may have differences of opinions to work through there. We took a less absolute approach with the previous drafts for a long time.
well, also, I think that a fair reading of Fracassi is that the law is pretty clear. You get quantum merit subject to a determination once you know the outcome of the case, whether you win, and if so, who did what to get you the win, and to come up with some formula before and then say, but it won't be enforceable if it puts a burden on you later, that creates a risk for the client. Now the client's got to make a decision. Gosh, maybe I don't want to fire this lawyer and then find out that I'm fighting over a burden later on. Whereas if the client just terminates like they have a right to do, goes to the second attorney, the case is won. Now the two attorneys duke it out, who among them shares in what proportion. And the client hasn't suffered the risk of I'm gonna have to make good on some larger amount if some court decides maybe it isn't such a bad burden.
So, and Eleanor, one of the reasons this version is so short is that we had a lot of factors to be considered in a case-by-case analysis before that aren't necessary if we go with this more absolute opinion. But I'm sorry, I didn't realize you were talking because it is quiet, so I'll shut up now.
Sorry, I guess I just don't read Fracassi the same way. It seems to me like there's daylight between an absolute obligation and quantum merit. Like if the challenge was to come up with something that was a conversion clause that you thought could be fair and not impose this burden, I think that might be worth giving some thought to, like just taking that on to further the discussion.
So we did that in the initial draft, and got uniform public comment that our hypothetical that said the conversion clause was okay was kind of absurd. It was just so built in with protections and client protections and somersaults, and so it was uniformly made fun of when we did that. I am very much open to others doing a better job of coming up with that, and then we can talk about it. But mine was found to be like a Rube Goldberg machine of client protections in order to get to that result. But I think it's a worthy effort. That's why we tried it, but we didn't get there, you know.
And we've been through that. I mean, over the last year plus, you know, is there some other scenario? And I guess there's new minds on the committee now, but we haven't received one yet that seems to fit within the analysis.
Yeah, I think Fracassi says we find no injustice in a rule awarding a discharged attorney the reasonable value of the services he has at the time of discharge, which the court noted, preserve the client's right to discharge an attorney without undue restriction, yet acknowledges the attorney's right to fair compensation for work performed. And that, and then the Fracassi case, among other cases, cite a number of examples where it doesn't work out. Anything other than that formulation does not work out to be a fair compensation. And Fracassi, well, I guess the Scapa Brown case also talks about the impropriety of trying to write around the Fracassi formula, as well as some of the other cases that we've cited in the draft opinion we presented now. I just think that if you quantum merit is quantum merit, it means the reasonable value of the work you put in. And having testified in a number of these cases now, about half a dozen of these attorney versus attorney cases, yeah, the first attorney is entitled to the reasonable value, whatever that may be. And there's a lot of factors other than just hours and rates and things like that. As I heard Marshall Grossman once testify in a fee dispute, Your Honor, of 1,000 plotting, I mean, a momentary flash of brilliance can be worth 1,000 plotting hours. I mean, it's subject to who does what among the two attorneys that's going to determine the reasonable value in comparison to the other. And there's just no way of calculating that until you know all those facts at the conclusion of the case. And
like a notion of a retainer. So
I'm sorry, could you say that again? I'm so sorry.
Could quantum merit incorporate a retainer? Like, would it ever give value to an attorney for time that might be subject to a retainer for like foregoing other work, for reserving time for a matter?
Well, but see, that doesn't come up in a contingent fee case because, I mean, you see all the ads, no, you don't pay a thing until we win. But the whole point of what justifies a contingent fee, which can result in an overall fee much higher than the reasonable value of the hourly services, is the risk that they're taking. And if you hedge that risk, then what you're saying is that the contingent fee amount or the percentage can be unconscionable because it's supposed to subsume or have the risk included in it. But if it doesn't, then you're charging too much. And there's plenty of cases which talk about that.
But are there cases, I guess, where quantum merit is given, where you're getting something well beyond hours that would incorporate that retainer type term, compensating the attorney for foregoing other opportunities?
Wait, say again?
Are there cases awarding quantum merit where attorneys are compensated for foregoing other opportunities? Is there?
Well, that's normally a factor in a lodestar, which is usually used in a fee shifting situation, where you're asking the other side to pay the fee. Why one of the factors is that they gave up other work. In a contingent fee case, they've already made that decision, and now the case has gone on, they're terminated. Now they're free for the rest of their time to do whatever they want, find a new case, and if they're smart, they will. And so how much they helped the case along while they had it and took on all those burdens is something that goes into determining their reasonable value. So you don't need to say it. If you try and guarantee what you get without knowing all the other factors that are going to go into it, you don't know until the case, you hedged your bet improperly.
Yeah, I just wanted to weigh in briefly on some of the issues that we're talking about. First, just Eleanor, I believe there are cases. The answer to your question was, in my mind, is yes. But the other issue I wanted to raise, there are a few, but one is I tried to catch up on the public comments that were circulated in advance of this meeting, I believe, based on my request. I think they went to the whole group, but many of the public comments disagreed with an outright prohibition and actually did provide some suggestions on hypotheticals where they felt it would be ethically permissible. So I think we can look to those public comments to get some examples. But one thing that I think might be just easier to address is I just kind of had a question, and this was based on a comment Brandon made earlier, which I understand, the opinion, the revised opinion has been drafted to define a conversion clause as one that doesn't entitle an attorney, that entitles an attorney to more than quantum merit recovery. However, when you look at the digest and stuff, that's not at all clear up front. And so if it's the working group's opinion that a conversion clause would be permissible where it doesn't entitle the attorney to more than quantum merit recovery, I feel that would be a useful clarification to the opinion, particularly when I looked at the public comments, and many of them seem concerned about the issue about, even if you could obtain quantum merit, you'd still have to litigate that issue down the road. And so, both clients and attorneys might want reasonable certainty up front. So I think that would be an important clarification response to the public comments if that's what the working group feels. I mean, I feel I think I've mentioned this before. Obviously, I disagree kind of with the outright prohibition, and I don't think it should be so limited as to, only a conversion clause that limits the attorney to quantum merit recovery is permissible. But regardless of that opinion, I just wanted to understand if the working group feels that a conversion clause that is limited to quantum merit, if that would be permissible, and if so, can we make that clearer in the revised draft?
Yeah, Sarah, that is our view, and that's why I guess we could have said it a couple ways. A conversion clause is impermissible if it exceeds quantum merit but we kind of changed it. We baked it into the definition because I've never seen a conversion clause in California that would purport to claim entitlement to quantum merit only or less, because the default in the absence of any language at all is quantum merit. So I take your point completely that our digest is not clearly reflecting what the opinion is reflecting, and we could say the bottom line of this opinion either way. We could say no conversion clauses that claim more than quantum merit, or we could say a conversion clause is something that claims more than quantum merit entitlement, and that's impermissible. Two ways to say the same thing, and I'm happy to say it in the way that strikes anyone as most clear. But I think the biggest issue here is seeing if we have agreement on that conclusion. But I agree with you completely about the digest and the way we're saying it.
Okay, thanks. And just since we're looking for, hypotheticals, and I apologize, I know that Joel had asked at the last meeting if we could provide those, and I was not able to get to those in advance because I had a week-long trial in between after our last meeting. But I do think that just if I mentioned this, I think at the last meeting too, is that I believe the hypothetical in our initial draft opinion was one situation where it would be permissible. I understand kind of the feedback from the LA County Bar Association that that's not really a realistic, perhaps, type of situation, but it's still a situation that could exist. And I do still agree with a lot of the factors in the Colorado opinion, even under California's unconscionable standard for fee agreements, that those would result in a fee that is permissible, such as where you're dealing with a very sophisticated client. The sophisticated corporation, for instance, is represented by a general counsel who negotiates and wants certainty up front, so negotiates this conversion clause, and where it's clear that the conversion clause wouldn't interfere with the corporation's right to terminate the relationship or right to settle, and wouldn't result in an unconscionable fee. I think that's the type of situation where a conversion clause would be permissible. And one of the, there are 3 or 4 public comments that kind of feel that it's a conversion clause is permissible under certain situations. And one of them, it's actually the anonymous one that goes into significant detail, about, I don't know, a list of like 10 or so factors, which I agree with a lot of those. And I think that could be used as part of the hypothetical. I think the LA County Bar Association gives a more simple example, and I'd have to pull it up. But so I just think those, I don't know if working group just disagrees with those kind of hypotheticals, but those are the hypotheticals I had in mind, both from the public comments and our initial hypothetical, and just kind of a hypothetical that tracks a lot of the factors that the Colorado Bar Association.
So Sarah, I think, first off, I agree that anonymous commenter was like the most thoughtful comment letter I've ever seen. And I really do wonder who it was. And that was very thought provoking. And I personally did disagree, but look, I think we have sort of a spectrum of options here. We can have a much more nuanced opinion that leaves the door open to conversion clauses under certain, some people would say very rare circumstances, but others might think they would occur more often. I was a little bit worried about leaving the door open because, number one, I do read Fracassi much more in line with how Joel reads Fracassi, and I think it's just a burden, and my sense of how it will be used is going to be burdensome. But that's a road we can go down too if the committee as a whole doesn't want to take the absolute approach out for public comment. I personally think that lesser opinion, even though it's suboptimal to me, has value. Not as much value, I think, as the opinion that we're putting in front of everyone today. But, I think we might need just some new blood on this too, because the drafting committee, we have considered all these things and just sort of been grinding against the full committee. Maybe we need to incorporate some people from the committee to get drafting with us on it too, and be part of the granular discussions, because we've worked ourselves up to this conclusion. I guess that's how I would put it.
Yeah.
My blood's leaving, so somebody can put their blood in now. So.
We're gonna miss you, Ken.
But Sarah, in answer to your question too, I mean, because that was last year, we went through as a subcommittee and in one of the committee meetings, all of those public opinions, including the anonymous one. And and I still recall with the anonymous one, there were various situations that whoever wrote that explained where there's it's problematic for the lawyer because they're going to have to get involved in litigation to enforce their quantum merit or whatever, and they're trying to hedge against that. But like a lot of them, I don't really think change the analysis. As I recall, there was one they said, it was an unlikely situation. I think another example that the person gave was, if the client refuses to do discovery and terminating sanctions are issued and the case is dismissed, and hence there's no recovery, the attorney should still be able to get a fee. But that's a lot of those where, quite frankly, I agree they're problematic. They are risks that an attorney in a contingent fee case takes, but I don't see what the anonymous was proposing in many of those situations is just not in the context of they're stated as contingent fees, but that's not how a contingent fee works. You either get your contingency occurs or you don't, and the law is very clear on that.
And the other thing I'd like to see if we get new blood addressed is the question of whether Rule 1.7 compliance is required, whether this creates a charging lien by the conversion to an hourly rate under Fletcher versus Davis. You get into all those questions where you might, even to get to a hypothetical, you might also have to include language that you have to tell them they have the right to seek independent counsel. It has to be fair and reasonable. It has to be in writing, all those kinds of things. And I've not seen anybody work through that. Because I didn't think it was necessary for all the reasons I've said. I think Percassi tells you what happens in this situation pretty clearly. But
I propose a straw poll, and anyone who votes against it has to join our committee, our working group.
I have one quick question though, just following up on the hypos, because I did think the LA County Bar Association provided kind of a very simple example of something that they viewed as ethically permissible, and I do think is perhaps a common provision as they refer to in some contingency fee agreements, which is where there's an agreement up front about the hourly rate that would apply in the event of quantum merit recovery. And so they viewed that as something that would be ethically proper, and suggested that the committee consider incorporating that type of example as part of the ethics opinion. And I'm trying to just pull up exactly.
Yeah, I know exactly what you're talking about, Sarah, because I was a spy at the LACBA meeting when that was discussed. I think it's a really interesting concept that has a lot of logical appeal. My concern with it is that it gets pretty weird because the quantum merit horse race, let's assume the contingency occurs and you're doing the quantum merit fight, it's between the two attorneys. And the second attorney has never signed an agreement saying, yeah, attorney one gets $2,000 an hour. You know what I mean? It's a little strange. It certainly doesn't harm well, it could harm the client if it prevents attorney two from wanting to even touch the case. But
yeah, it does create a disincentive, and also well, like I said, it creates a disincentive, and it's also unreal. It's not quantum merit, because once you get into quantum merit, one of the things is you're looking at the rate in the community of similar lawyers handling similar matters. And that's subsumed in it. And once you try and get attorney one to create this, I get a higher rate than the community value, second attorney might not want to take the case, might not want to fight that fight, depending on where the case is. And it operates as the disincentive on the client exercising the right to terminate the first attorney, which is exactly what Percassi is trying to held needs to be protected.
Yeah, I just feel that that's a situation though where the attorney and client, would want certainty up front to avoid having to litigate that issue down the road. It doesn't necessarily mean that it's going to be an unreasonable fee or not within kind of the community standards. It might be at the upper end, but if the attorney and client negotiate that in good faith, I don't see any ethical prohibition on that under the rules. But I think I interrupted. Ken was about to speak too. Sorry about that.
Yeah, I was just gonna say, I mean, I've seen clauses, if I'm discharged and, for quantum merit, my hourly rate is this. And those have popped up. I've seen in fee arbitrations and other fee disputes. I'll be honest, I have never seen a situation where that was explained to the client. I mean, as a reality, most clients, when they're hiring someone and on a contingent fee, and we're not talking about corporations, the vast majorities are not, they're auto accident or other kinds of cases, injury cases, where they can't afford to hire a lawyer and they want the contingent fee because they can't afford to hire a lawyer. And that's what's discussed, and that's what they focus on. Anytime I've seen that come up in a fee dispute, the client has had no awareness of that until it was raised in the fee dispute, to be honest.
Yeah, I just want to say, Cassidy, I see your comment in the chat, and we'll take a look at that, obviously. But it is, I mean, if you're seeking some kind of protection or proprietary interest adverse to your client in the right to get a different fee upon termination than without termination, you're really negotiating an interest adverse to the client, and that may require some additional ethical compliance, which hardly is ever seen in these cases. And in fact, if I've seen comments from the CRLA, they often say, "Don't make me go to don't make me send the client to an independent lawyer just to sign my own contract." So, and you've got to start with the proposition that reasonable value isn't good enough. And I'm not sure that's a proposition I want to be promoting. Ricassi says it's good enough. It should be good enough, and it protects the attorney for the effort they put in and the risk they take.
So I think I have a sense of the rooms, but from what I'm seeing, there are 3 people who agree with this position, and they all happen to be on the same drafting team. And from what I can tell, everyone who is not on the drafting team thinks that there should be some instance, maybe very narrow and going through all the acrobatics that Brandon was talking about that were displayed in the public comment version, where a conversion clause should be permissible. Is there anyone who is not on the working group who also thinks that conversion clauses should never be allowed?
Yeah, I want to say, I don't think we've ever put that up to a vote.
Did we take a straw poll?
We did a straw poll at the last meeting, and that was found not to be the case. The majority said we should go forward and present no exceptions.
That's true, actually.
Yeah, actually.
We did vote on that last.
Okay. Because I think we have very similar conversations to the conversation we're having right now every time this opinion comes up. And I don't know that anyone's mind has really been changed on either side. So I think that, to Brandon's point earlier of should we take some straw polls or what have you, or add, people who disagree with the working group's draft to the working group, so that more attention can be taken to it. I'm just trying to think of ways where we can decide either to table this opinion or create some forward momentum.
Well, let me make a plea. We kind of jumped the gun a little bit to get this to this meeting so that Justin could weigh in.
I have things to say.
Start talking.
Yes, I would love to hear, because, I mean, honestly, the way I see it going forward, because I'm sensing a great deal of concern or hesitancy, which is just fine, is that we should get some new people on this drafting committee, and see where we go from there. But Justin won't be here next month, so I do want to hear what he has to say before we figure out what we're doing next.
Sure. Well, it was good to hear that some fresh perspectives on this. I'll try not to repeat things that we've said in prior meetings or that have already been emphasized today. Except for one, I do want to reemphasize for Cassie, unless I'm misremembering that case, the way that the folks in the camp that are not yet on board with the working group is distinguishing that case on the basis that it wasn't actually a conversion clause case. And so if I'm remembering that correctly,
right,
for me, that's a big deal that we're kind of hanging our hat on a case that is not about an opinion about conversion clauses that is dependent on a case that wasn't actually a conversion clause case. And I just, for those who are currently in my camp here, I just highlight that to keep in mind as we go along here. In further meetings, that for me that is a significant distinction, and that I still have concern about hanging our hat as much as we do on a case that really isn't about conversion clauses. A couple things I want to say, but let me start kind of to echo Sarah on the definitional issue. We're pretty precise in the earlier iteration where we say that a conversion clause is a contractual provision that, if triggered, converts the fee to an alternate fee arrangement, period. Now we've not completely, but it's redefined that a conversion clause is, based on the new baked in definition, always one where the conversion is to something greater than quantum merit. So it's, to me, materially different in how we previously defined it for public comment. And so I guess my reaction to that is, let's figure out what the most precise way to define a conversion clause is. If it's more appropriate to broadly define it as to converting to any kind of alternate fee arrangement, whatever that might be, as we have in our earlier iterations, let's stick with that and then massage the language of whatever our opinion becomes, rather than redefining it in a way which my present concern in the new definition is that it may not jive with how that conversion clause phrase is used in ethics opinions kind of universally. So I do think that merits a further examination, and I'll leave it at that. I echo what Sarah said on that. I worry with this latest draft that where we are now is kind of making a legal statement that a conversion clause, as defined, i.e. something resulting in something beyond quantum merit, is never allowed. It's just a legal conclusion, as opposed to an opinion of this committee that provides ethical advice in an area that has gray. So before, the original iteration was, look, there are some real ethical pitfalls when it comes to conversion clauses. Here are the concerns from an ethics perspective that you need to watch out for, reader, right? It was this may be unethical, and here are the considerations, which is what a lot of our opinions deal with, trying to work through the nuances, the gray, to give advice so that lawyers make good decisions. But right now, in this latest iteration, I worry it's not really an ethics opinion giving advice in the gray. It's more of saying black and white, here's our view of the law. Whereas I think before, in our earlier iterations, we were working more in that gray, working through the ethical nuances, giving the type of advice that I think we more typically give in our opinions. So I just say that I wonder then, what is the utility of an opinion that, at least from my perspective, might just be spitting out our version of what the law is, similar to what you see in Fracassi, saying here's the law when somebody was going to get 33%, but then they're terminated. In that instance, where there's no conversion clause, they would get quantum merit. That's a statement of law. It's not a statement of ethics. And so I worry we're headed in that direction. And so I just want to caution about that going forward, and see, if we do take this tact, at least try to build in more discussion to the extent appropriate about those kind of ethical considerations, rather than just saying it's ethically impermissible. Is there something more that we can give to the reader that might be beneficial? And then let me just throw out two more things. One is, maybe this seems like an absurd hypothetical, but what about if in the agreement it says, because the lawyer is an ethics nerd and wants to test the validity of our current view, and the lawyer puts in the engagement agreement that the conversion clause is quantum merit plus $1. So is that unethical? And I think that sort of silly hypothetical like that, I think, pushes the envelope for us to think about that. Is that really unethical? And if it is, why? And if it's not, or we can't say, why not? And for me, that then comes into this discussion of unconscionability versus reasonableness that we've already had. But I think it's worth considering this in that sort of the vacuum of an abstract hypothetical like that, and see where we come out if that's the hypothetical. There was one other thing I wanted to mention that I don't think I still have a clear answer on. Looking at some of the other ethics opinions, there was mention of Colorado, but in particular the Virginia opinion from 2005 asked the question, well, can you have a conversion clause that allows for something other than quantum merit? And the answer, as I remember the Virginia opinion, was yes. And then, when I brought that up in other meetings, the discussion then came to, well, in California, we have this unconscionability concept, whereas in other jurisdictions, they don't. But I'm not sure that that our use of the terminology in California with unconscionability actually, in practice, I question or don't know whether it actually matters in terms of how other jurisdictions look at this conversion clause analysis, because at least as I understood the Virginia opinion, it was suggesting that you could in fact have something other than quantum merit that would be appropriate for a conversion clause, and you would look at their version of 1.5, which talks about reasonableness, not unconscionability, but that would suggest that even though they're using different terminology, it's a very similar analysis. And so that distinction that has been raised by some of our members that California is different, I'm not so sure that holds. And so I would at least commend for further consideration opinions like the 2005 Virginia opinion, which suggests that you can have a conversion clause that's something different than quantum merit, and try to better understand, well, if our conclusion truly is that doesn't work in California, I think we need to have an articulation as to why that is, because I'm not yet persuaded based on what I've read to date. So those are my 5 minutes of thoughts without trying to duplicate what other people have said. Thank you for listening.
Can I ask one question, Justin? On your points 1 and 2.
I don't remember what points 1 and 2 are. So
the points, they were about, does Fracassi do it? And
yes,
I can't remember point 2, but I wrote down points 1 and 2. It's the same question. Do you discount, or what do you make of the Scapa Brown case, which says that it is a disciplinary violation to try and contract around Fracassi?
Well, it depends. So I don't remember the Scapa case, right? So it depends on in what context Fracassi would apply. Go ahead. Is Scapa a conversion clause case?
It's many, Justin, Scapa's many things. The attorneys did like 8 terrible things. One of them was a conversion clause that says, we're contingency fee lawyers, but if we get fired, we get $600 no matter what.
That's your $1 example.
Yeah, and in the opinion, the state bar court, talks about all these terrible violations, but does say that knowing that, and it's really interesting how they phrase it. They say the Scapa Brown attorneys knew that Fracassi meant they were limited to quantum merit, and they attempted to contract around it, and that was a breach of their ethical duties. Now, I will freely admit that I don't know how this would have turned out if the attorneys hadn't done 65 other terrible things, but the language in Scapa Brown was pretty compelling. So it's a tough one.
Well, that's interesting. That's the first I'm hearing, or at least remembering, I should say, of a case where a conversion clause that is purporting to allow for recoupment beyond quantum merit is not permitted under a California case. And so if that's the fair reading of Scapa, I then wonder why not highlight that. Either A, highlight that over Percassi, or B, if that's the law and it's clear, why do we need this opinion? I say that hypothetically, or rhetorically. I'm not suggesting we don't need the opinion, but if it's clear under Scapa that that's the law, then what's the point of our opinion? Again, that's a rhetorical question,
right?
More than anything.
Now, I hope I made it clear. I was trying to make it clear that I do think that is the read of Scapa, but Scapa is a drop kick of a bunch of attorneys for a lot of things, and I could see how people thought that was just an extra body blow to throw in there. It wasn't the central focus, but it is in there, and and we had Scapa sort of highlighted in our prior drafts, and we argued about it a lot, or we argued for the conclusion that Scapa supports the shutting the door. I know people aren't there yet. I think Joel and I had in mind a vote on getting this out the door for public comment. I don't know, Joel, if you're still wanting such a vote. Seems like we're not going to win such a vote. So I wonder if we want to just move to, getting more members on this subcommittee to have the working.
Brandon,
yeah.
Brandon, what I agreed with you on is that whenever this leaves the committee, it's going to go out for a full round of new public comment.
Okay, I misunderstood. I thought you wanted to do it today. Yeah. I got you. So
I mean, we got to, if my view is that either we come up with a way to get this out as a no exceptions opinion, or we don't get anything out at all. I don't want to put out, especially if in light of Justin's comment that, well, why do we need this opinion at all? If I don't want to get out an opinion that suggests we endorse any exception at all. And so I would vote against it. But if we can come to a consensus that it should be a no exceptions opinion, then I know we have to go out for a whole new round of public comment and start over.
Right. And I am of a slightly different mind than Joel in the sense that I believe the no exceptions opinion is the right one, but I still believe like our prior iterations have value and will go some distance towards shutting down what I think is an unethical practice. But I'm just trying to figure out the best way forward. I'm wondering if we should have one or two of the most skeptical people on the committee at large join our working group and dig in with us. Because I don't really know how to, one of the problems we're facing here is that Joel, you and I and Ken have really been driving this, and we have our views and they're not carrying the day. Maybe we need some more people on this opinion, or we need to just let it go for some period of time. I'm not sure what the best path forward is.
Well, the trouble is what started us down this road 4 years ago was the recognition that there's a lot of mischief out there.
Yeah.
Because nobody reads some disciplinary case like Scapa. And it was incumbent upon us to fulfill the duty of protecting the public at large is to advise attorneys that they can be violating the law, violating their legal ethics by having these conversion clauses because they work so much mischief. So I'm all for, I'd give it one more try, but after 4 years, I'd really like to have somebody commit to getting in there and working through this thing, and so we can come to that decision. Can we say it's a no exceptions rule or not?
I just want to add too, kind of respond a little bit what Justin said. we have gone through all these opinions. And, and you mentioned the Virginia one from 2005. We went through that one as well. And, in that opinion, they did not find the conversion clauses to be ethically permissible. It was a weird, if I'm remembering correctly, it was something to the effect that if terminated without cause, the reasonable value will be, and it specified what an hourly rate was. And that committee concluded that just because it says that in the agreement doesn't mean that's it or it's a reasonable fee. So they did not approve that clause. And to the extent they did kind of leave a door open, there was a clause, the last sentence was something to the effect that it had a proviso where permitted by law, the reasonable value will be, and there was if there was a settlement offer made prior to termination, where permitted by law, the reasonable value, the attorney will get their contingent percentage of that
That was the
settlement
one.
offer.
There was a $10,000 offer on the table when they were fired. The new lawyer gets $75,000 settlement. They gave the first lawyer 30% of 10,000. I think that's the one.
Yeah, and they didn't approve that clause either. I mean, so they did say, the fact that it said, something they said where permitted by law maybe didn't make it per se unethical, but they didn't approve it as it was written. So, like I said, we've gone through all these other ethics opinions, and and reasonable minds may disagree, but while they kind of didn't come out quite as firm as our latest draft is, they didn't approve the conversion clauses in any of those opinions.
Well, obviously, we're not carrying the day today. I really do. I mean, look, these are reasonable differences of opinion. I welcome new volunteers to the working group, or else the working group is going to self-destruct or something. I don't know. We need help.
So
if we think there's value in this topic. So
yeah, I think there is value in the topic. And since I am one of the ones who has been outspoken in, my disagreement with the outright prohibition, I'm happy to help to join this working group.
Happy to join and happy that Sarah's joining.
Oh, so it'd be great if you want to join too, Eleanor.
Yeah, I'd be happy to join as well. Maybe we can.
Thank you both. Thank you both so much.
I also just had a quick kind of question, because Joel had referred to California Lawyers Association comments, but I didn't see any. The only ones I saw from bar associations were from the Orange County Bar Association and LACBA. Is that right? They're just I'm just surprised that California Lawyers Association wouldn't have commented on this, but it seems they didn't.
I don't remember. Are you looking at the pile of comments right now, Sarah?
Yeah, I just saw the two at the very end, the LACBA and.
Yeah, I think you're right. I don't recall Cal Lawyers.
Okay.
We burden
There
this
were consumer attorneys, there was Orange County Bar, there was LACBA.
Okay.
Yeah, I meant the CAOC. I didn't mean Cal Lawyers.
But Anonymous blew them all away. So
I know. I really wish they put their name, but
they could join the working group. Well, listen, I think we've talked at length, and we really appreciate everyone's attention and patience, and we really appreciate the two new volunteers, and we will see where we can go. It's been a long road, and maybe some fresh energy will help us a lot.
Okay.
Sorry, I was on mute. I don't know if anyone saw Eleanor's comment, but I think it would be helpful to have kind of in one email, because this has been going on for a while, for the working group and perhaps in advance of our next meeting for the full committee too, just a package that includes the earlier drafts, public comments, and any key cases or research files. So if you have any of those, maybe the working group that you've already put together, if you could maybe email them to Angela or something, and then she could circulate it to all of us. I think that would be very useful.
Yeah, I've got my working folder with all my notes, ethics opinions and all that. I'll be happy to send that along. I think the other Joel and Brandon probably have them already, but.
Yeah, but Ken, if you have it all in one place, that's even better.
What was that?
If you have it all in one spot, that's better than what I've got going on.
Yeah, I've got a lot of mine in one. Who am I sending this to? I lost track now. To Mimi or?
Well, I was just seeing Angela. Does that work? Erica and Angela for you guys? Is that okay?
That's great. Thank you. And then we can see what might be missing and add to the file.
I'll send it to Angela and Erica. How's that?
Yeah, and in particular, if we could get that, I think I pulled it, but it wasn't from 2005. It was from 2000. I'm not sure if I have the right Virginia ethics opinion. So if we could include that one,
There's two of them. There's the one from 2005, and then there's the. Is it a different
one?
Maybe
Maybe that's why I was getting confused. There are two. Okay.
There's a 2020. Well, yeah, I've got a 2023 one. So yeah, I'll send along what I have, so you guys have all that.
Great, thank you very much. Sorry, Erica, were you about to say something?
No, I wasn't. Raquel has her hand up, but I wasn't.
Oh, I didn't see that. Okay. Raquel?
Hi. And can you also, in this compilation of this history, top line, what is a sentence, a statement? What is the point of contention? I realize I thought I understood it, but I'm not sure. So that could be helpful, definitely for me. But maybe even for the new people who join, so we kind of are all clear on what is it.
I'm not sure what you're asking. What you mean? What is a contingent fee? Is that what you're?
No, I know what a contingent fee is.
Oh, okay.
What is the point of conflict, of difference? So we've been going as I don't remember, one of you gentlemen said, like, we've dealt with all these cases and we feel like we put it to bed. And so I'm just saying, I've heard a lot, but it's not clear to me. If somebody said to me, what are the two sides? I couldn't answer. And so what I'm saying is just top line a statement as part of the compilation as to here is the difference of viewpoint. Is it that there are no exceptions to this conversion clause, or is it something else that Eleanor and other people are saying they don't read the case law to go that far? So whatever it is, I mean, if I could be specific, I wouldn't probably be asking to have the statement. And so I thought, for example, Joel, in what he did, it was clear to me from the last meeting what he was trying to, the objections he was trying to allay to rest. That was clear to me. And now as we go forward, it's not quite clear to me, what are we trying to allay concerns about?
Well, hopefully the new members will have their own fresh view on this and we'll find out.
So we want to go all the way fresh. Have we been working on this for 4 years? I thought we were trying to go forward, not back to go forward.
Well, but sometimes you got to back up to go forward. And I think if we've got some people who still hold the view that we're on the wrong path, let's go back and start looking at the signposts again and see where we end up. I'm willing to take a fresh look. Let's do it. But it's by taking that fresh look, I hope we're all committed to getting to the end, whatever it is, of putting this to bed.
So it may be because I'm not an attorney that I'm not specifically clear, but I will say, as to not be clear on what we're trying to put to bed, I can't be as helpful. And so that was my reason for saying, we're going to have a lot of documents. and I'm gonna read them all, but what are we really, what are we still struggling with? What is our point of struggle? So that we could all come to the same page of either saying, forget it completely, or yes, we can move it forward. So that for me seems like a reasonable request.
Yeah, Raquel, honestly, my top line summary right now would just be that we all recognize that we see conversion clauses being used in ethically abusive ways. And right now the debate seems to be whether the prior draft, which says these things require very, very high scrutiny to make sure they're not unethical, and the current draft, which says they are just never permitted. They're ethically, that's really the, and it's a big point because the law is complex on this, and the issue is very, we're slicing these onions pretty thin, and everybody's coming at it with like their own good faith impression. But that's, as I understand it right now, really the battle. And the last thing I'd say on that is that, as Joel expressed, he has said several times that it's his view that only the absolute prohibition makes sense, that he can't even get behind the one that says these things are really suspect and likely to be unethical. He thinks that's providing daylight where there should be none. That's really the contour of what we're trying to get consensus on right now.
Yeah, I'm willing to be convinced on that latter point, but it hasn't been yet. And I've looked at all the law review articles, all the cases that have been cited, all the hypotheticals that have been proposed, and I am not yet convinced that any of them are going to pass muster under Fracassi and Scappa and Cazares. So I'm willing to listen again, but let's give it a good faith try and let's see where we go.
Hey, thank you all for 4 years of consideration on this so far, and we'll see where we go next.
All right. And thank you to the working group. I know you've, worked hard on it, and, and I did appreciate that revised memo kind of explaining the reasoning that Joel put together. So I just wanted to move on to another agenda item now that's also been ongoing for quite some time, but we have some public comments to consider on the lawyer acting as an expert witness opinion. And Angela, if you're able to share your screen. And I also wanted to thank Angela for putting this kind of summary together of the public comments. And I'll just go over them very briefly. I think unfortunately this time I wasn't able to put together with the working group kind of any proposed revisions to the ethics opinion in response to the public comments. But I do recommend that we do, following this meeting, after talking about it, make some revisions based on the public comments we received. So we received 4, I'll just say 4 comments from individuals. One of them was not applicable, so I'm not counting that one. And then 2 from bar association groups. So the individual comments kind of felt that the opinion, disagreed with the opinion, felt like it would jeopardize the duty of confidentiality and attorney-client privilege. But they really didn't provide any kind of explanation. It was just like a very short comment or suggested changes. And so it's really hard to figure out exactly what to do in response to those types of comments. And that the confidentiality kind of discussion, the current opinion does address that in many instances in terms of, I think that's part of for many of the hypotheticals, the opinion does already make clear that there would be potential rule violation situations where it would involve a violation of the duty of confidentiality or attorney-client privilege to the client. One of the comments was just very short and supported the opinion as is. And then another one just opposed it, feeling there would be too many conflicts against representing clients if this opinion were adopted. So unfortunately, the individual comments, unlike that anonymous comment we just went over, didn't provide a lot of detail to support the comments, but the the Orange County Bar Association did provide some helpful feedback in with suggested edits in a letter dated August 15th. And they, you know, both the Orange County and the California Lawyers Association provided feedback, some of which it seems like they must have been working together because it was very duplicative and it's almost the same language for many of the comments. So I'll start with the Orange County because theirs was submitted first. So I think they were concerned about language, and this is appearing on, I'm trying to see, I don't have it handy right now, but language had said that the rules 1.7, 1.9, and 1.10 apply when the conduct in question could be viewed as the practice of law by a layperson. They felt that was just not a correct statement of law, that it's not, whether something constitutes the practice of law isn't based on subjective views of a layperson. And similarly to that comment, the California Lawyers Association echoed that comment and also mentioned they felt that the opinion conflated the issue of whether you're entering into an attorney-client engagement relationship as opposed to whether the attorney is engaging in the practice of law. And I agree with the comment about the practice of law, kind of that statement. There isn't any support cited in the current draft for that statement, and I don't think it's necessarily a correct statement. And because we're actually, my understanding, and I wish Steve Bundy, prior member, were here, because I know he went into a lot of detail on this based, I can't remember the ethics opinion in the past, but an issue that, you know, COPRAC doesn't really opine on what constitutes the practice of law. And therefore, you know, I don't think we should really get into it too much. And I think that we can refine the problematic language by simply stating that we're assuming that the attorney is not engaged in the practice of law without trying to opine on what would constitute the practice of law, since I don't think that was the intent of our opinion. But I do think the language they've highlighted is problematic. And there is some additional language we could get into, but it's mainly, it's governed by case law to some extent about when an attorney-client relationship would be formed. We could consider adding that. And then another comment from the Orange County Bar Association was they felt that the opinion, in addition to the hypotheticals being addressed, that we really should address a more common scenario, which is where the lawyer is not just a testifying expert. Their role isn't limited to testifying expert, but they're initially retained as a consulting expert and then later designated as a testifying expert. And I do, you know, and they feel that that's a common situation that the ethics committee should address. I do note, I don't think they mentioned this in their comments, but footnote 5, and this opinion has been going on from quite some time, so I don't remember the origins of this, but footnote 5 does explicitly state that we're not addressing a situation where the lawyer is a consulting expert. So we disclaim that, and I think I don't remember the reasoning exactly, but I think we were trying to keep it a little simpler by not getting into that nuance. Although I think we could consider two things based on the feedback provided. As one, you know, do we want to, you know, address that situation now, or is it something that we could consider as part of like an addendum or another opinion down the road to address that situation, given that this opinion's been going on for a while? And my, you know, my personal recommendation would be that we continue to kind of exclude that from the scope of this opinion, although I don't disagree that it's important to potentially address down the road. And then I'm trying to think of the next comment was regarding page 5 of the opinion, where we state there's no indication that and this is where it's a lawyer first and then serve after being a lawyer serving as a testifying expert against the lawyer's former client. And in that situation, the line says there's no indication that the lawyer's testimony would injure the former client. And they felt that statement was just too conclusory, and we didn't get into enough analysis of that particular issue, that hypothetical we focused on the duty of confidentiality more. And I tend to agree with that feedback. And I think even clarifying, that sentence in terms of there's no indication the testimony would injure the former client with respect to the former matter, kind of just clearing that and providing additional details to support that analysis would be useful. And the California Lawyers Association also echoed that particular comment, that there should be an expansion of the discussion on the duty not to injure the former client. And then the next comment, which came from both the Orange County Bar Association and the California Lawyers Association, deals with the next hypothetical, which is the testifying expert who then serves as a lawyer. And there's a discussion about kind of there could be other contractual duties that might preclude the representation based on the testifying expert's agreement with the party, and that might preclude the representation. But they also suggested that we consider not just contractual obligations. Well, I guess this would be partly a contractual obligation, but also address the situation where there's a protective order, perhaps a protective order issued by a court, and whether in a situation of protective order that could be very stringent, we might want to warn the reader that in that type of situation, there might be a situation where you wouldn't even be able to get a waiver for the lawyer to then take on a representation that would be adverse to the former, I won't say, I guess the client, I don't know if it's the right word to term, use the client of the testifying expert. So just a caution about that. And then the next comment, again, echoed by the California Lawyers Association, was the concurrent representation of a client while a lawyer of that firm is acting as a testifying expert. So I'm going to pause here because I think I'm hearing a question from the conference room. Okay, maybe I'm wrong. So they felt that there are important factual qualifiers in this particular hypothetical that makes that are very important, and we should emphasize them up front in the digest. And I agree with that. The other comment is just, and this kind of is similar to kind of the concerns we've had as a committee as we've discussed this opinion overall, including some that Brandon has raised, is just, some discomfort with the ultimate conclusion reached, where we're relying on this Illinois opinion to a large extent to reach the conclusion that given the facts of this particular hypothetical, there wouldn't be any issue with the expert being adverse to a current client of the law firm in an unrelated matter. There were concerns raised about that, and they felt that we needed to really beef up the discussion about the ultimate conclusion, address the duty of loyalty, whether there could be potential imputation under Rule 1.10. So I think, right now that discussion of the hypothetical 3 is pretty limited, and we could expand on that to address it, and we could consider more potential application of Rule 1.10. I believe we did in the past and decided it wouldn't necessarily apply in this situation where the lawyer is serving as an expert. And then the final comment, which was, I think, a little bit inconsistent, and I'm blanking on who said what now. I think it was the Orange County Bar Association who felt that we shouldn't really necessarily get into the issue of expert disqualification under case law standards. Actually, the California Lawyers Association was the one who said that. And I think the Orange County Bar Association felt that was something that perhaps we should discuss more. Right now, it's limited to kind of just like a clarifying type footnote, more to alert the reader, and I think that's proper for the reasons California Lawyers Association also seems to suggest that's really an issue of case law standards that isn't necessarily appropriate for an ethics opinion. let me just see if there's any other that I'm missing. I think the only other one was just dealing with the issue that I mentioned earlier about, kind of contractual obligations that the testifying expert might have to the former client, dealing with the hypothetical too. There was also language used that says common law obligations, but it was never really defined, and they weren't sure what we meant by common law obligations. And frankly, I'm not sure either. That wasn't I was not the original drafter of this opinion. I don't understand what that's referring to. I'd have to look into it more, but it might be something that we just want to take out, because I think it's better to focus on the contractual obligations or maybe a protective order. I think the term common law obligations is somewhat vague, and unless we can come up with an example among the committee, I think it's better to just take out that confusing term, common law obligations, that might be owed. I think that's kind of a high-level summary of all of the public comments we've received, which I do think warrant a further discussion with the working group, and then perhaps suggested redlined edits we can make for the group to consider as a whole. But I did want to get kind of everyone's high-level feedback. And I also think we might unfortunately need someone else on the working group to assist, given that I think Justin's on it currently. But I'm not sure if there's I'm sorry that I don't have it handy right now, but I don't know if who else is on the working group. Raquel, I forgot if you're on this one.
I am not.
Okay, so I don't know. Angela, do you have the working group?
I'm gonna look that up right now.
Might be.
It's Brandon, Joel, Justin, and you, Sarah.
Oh, okay, that's great. So then I was wrong about Justin. Okay, so it's I think I was confused because he did the ethics symposium on it. Okay. So I think Brandon and Joel, we should probably follow up after this meeting on the public comments more. But if anyone, because I apologize, I didn't really have a chance to vet them with the working group in advance of this meeting. But I'll just open it up very briefly now for kind of a discussion if anyone has some kind of feedback on the comments.
I'll very quickly say that I thought the comment letters better articulated what I was poorly articulating as my concerns with scenario 3. I don't think we have the right result in scenario 3. I don't think so. But I mean, we got to work through it and dig through it. But I thought they were really good comment letters and lots for us to work with.
Yeah, I agree. I'm sorry. Dan, were you about to speak?
Justin, I was just gonna piggyback on what Brandon said. And I can't honestly, it's been so long, I don't remember exactly where I went with the presentation preparation I did on scenario 3 for the symposium, but I recall looking and wondering, okay, well, how do we deal with the Commonwealth case and California cases? And just trying to jog my memory, I just looked and confirmed that the American Airlines case, California appellate court cites Commonwealth, and I think it actually distinguishes it, but then there are 4 or 5 California federal cases that talk about the Commonwealth case. So I think that as far as in terms of next steps, we should look at how these California state and federal courts have looked at the Commonwealth case and see if that gives us more comfort or more heartburn in terms of relying on the Commonwealth case. And then also if it also suggests there are other cases we might want to cite in lieu of or in addition to the Commonwealth case. So that's what came to mind there. And then since I'm talking, my only other comment is to agree with you, Sarah, about the consulting versus testifying expert. My memory of that is we had a number of discussions about how the opinion was enough of a mind twister as it was, that if we were to add a discussion of the consulting experts scenario and how the privilege is implicated when the expert does not become a testifying expert, but remains a consulting expert, would have just added too many dimensions to what is already a difficult opinion to work through. So I agree with your conclusion there. That's what I got.
Thanks, Justin. And just to clarify, I think you're right that that's one situation we don't address, but the other situation that I think the Orange County Bar Association was referring to, and I might not have articulated it clearly, was a situation where they do become a testifying expert. They just start out as a consulting expert. So I think our opinion is kind of just assuming that they're the testifying expert all along, which is what the concern was. But either way, I still think it would complicate the current opinion if we address the role of a consulting expert, and the potential conflicts based on that, which could potentially, that part of the role, I believe, could involve the practice of law where the attorney is acting as a consulting expert. And it would just require a little bit more nuance, and perhaps that's the thing we address down the road, but I agree that we shouldn't address it now. Okay, so I know it's getting late, and I think we'll just follow up as a working group to discuss some of these issues. And I do agree with both Justin and Brandon, their comments about kind of this third scenario. And the duty of, I agree with looking into, because I don't know that I've done that personally, looked into kind of the cases that have applied, the Illinois case. But the reference to the duty of loyalty, I have looked into those cases, and the issue I've always come across is they're dealing with situations where the attorney is acting as a lawyer in a lawyer-client relationship, as opposed to the attorney acting as an expert. So the duty of loyalty cases aren't really directly on point, but hopefully looking more into the cases that I've cited to the Illinois case will provide some additional clarity and kind of insight for our third hypothetical. Let's just see. So we are now on to the agenda item D1, which is discussion of the draft ethics opinion on flat fees and termination. And Joel's going to be presenting this item.
You're muted, Joel.
Wasn't that Ken?
Yeah, I was going to say that I was the lead drafter on this one.
I apologize, Ken. I didn't realize that. So if you would like to lead the discussion, that would be great, Ken. Thanks.
Yeah, unfortunately, I didn't get as far with this opinion as I had hoped to get before I rolled off. So the last version I had for the last meeting, which we didn't get around to at that meeting, was to kind of clean up, in response to some of the comments from other committee members about shortening it, taking out what, some of the analysis that may not have been necessary. So this was my effort to do that and kind of pare it down. I have not gotten to the point where, though I had finished drafting, I was still thinking another hypo or two might be helpful, but unfortunately, I have not gotten around to that. And so at this point, I don't know whether Joel or Brandon might want to jump on and take the lead, and somebody else can take my position. I will happily share all my authorities. The issues we kind of struggled with were, the renegotiation issue and the disclosure issue, whether it's just simply the disclosures that are in the new rule or whether there might be some ethical obligation to go a little bit above that. So I have, as far as we've gotten is in the current draft. I do have all my research and authorities that I will be happy to pass along, and certainly if anybody has any commentary on the draft as exist, I'm here to listen and provide whatever feedback I can while I'm still on the committee. For the record, though, my granddaughter likes it, so. Just kidding.
Gotta love grandchildren.
Yeah, and by the way, thank you for that, Sarah. My granddaughter's she was born while I was on the committee, and with the virtual meeting, she made occasional appearances, whether I invited her to appear on the committee meeting or not, but and she turns 3 tomorrow.
That's a great age.
So if
So,
anyone has any questions or comments while I'm still, and feel free to reach out to me after, I've rolled off on this. I'm, to the extent that is, I'm not, obviously I won't be a continuing advisor or any official capacity, but if anybody wants to bounce any ideas off me, to the extent that's permissible, I'm happy to help.
Knowing that I can never be as articulate as Ken on this topic.
Now I can't hear you, Joel.
Huh?
Okay, that's better. Now your sound is somewhat muted.
I'm unmuted.
Oh, that's better now. Okay, no, but yeah, I was having a hard time hearing you there. Okay.
Okay, what I was saying, Ken, is I'm not sure I could do as good a job as you've done on this thing, but if everybody will give me their comments, I'll take over as the lead drafter, and if we can get someone else to join the working group who's interested in this, so much the better, but we'll be so much the worse without you.
Well, hearing nothing else.
yeah, and thank you, Ken, I think that was very kind of you to volunteer to continue to provide some advice even while you're off the committee. So if we don't have anyone who wants to volunteer now to join, I think the working group will be Joel and Brandon, but if anyone wants to join, if you could let us know now or even email after this meeting, if you decide you'd like to join. And on just a logistics note, Erica or Angela, will we have some new committee members joining us?
Yes.
Our next meeting?
So at our October meeting, there are 2 new committee members joining. So we will, offer up opinions to join as part of the drafting teams.
That sounds great. Okay. So does anyone have any comments on this current draft opinion of the flat fees and termination? All right, so not hearing any. Hopefully we'll get someone to volunteer from our the new members at our next meeting. And I'm going to move on to the next agenda item, which is discussion of arbitration advisory 2022 OXA, which is the standard of review and fee disputes. And this is updating a former fee arbitration advisory. And I believe this is the one that Joel, you're taking the lead on. Am I right?
Yeah.
Okay.
I confess, when I packed up to get ready to come to this meeting, I don't think I brought my clean draft of that one. No. So what I attempted to do was just clean it up in light of the significant case in this area, which came down, 2 years ago, which is the PECH versus Morgan case, which criticized the committee, the former mandatory fee arbitration committee, for not answering this question beforehand with an advisory, and so felt it appropriate to address it and point out that we had addressed it in the sense that this is how we train people, and it's also part of the guidelines that were approved by the Board of Trustees as far as what you're supposed to do in deciding a fee dispute. But the first thing you do is decide, is there a written contract? And if there is, you would force the contract unless you find it's unconscionable. So that's what I tried to update it to say, and it's kind of a no frills deal. And I'm open for any input.
I just want to say, Joel, that I thought the court in Peck said that our prior opinion was sensible. They didn't criticize us, did they?
No, it did. No, it said we had not said so in a whatever an advisory before, although we had said it over and over again in everything we did. But that's another story. Anyway, also, I guess I can't remember what the exact point was, but I was cross-examined about the old advisory and had to explain how it was changed by the Beck decision. And I thought it was better to do it in an advisory so that every other fee arbitrator would be prepared for that.
I can give you a few comments, unless other folks have. Okay, well, I really like that this is short and sweet and reader friendly. So I'm really pleased where you are with this. Just I think some of my comments are just minor to help reinforce the clarity of what you've already done, Joel. I noticed on the red line